and princes decree justice, and from whom alone cometh all counsel, wisdom, and understanding. We, thine unworthy servants, here gathered together in thy name, do most humbly beseech thee to send down thy heavenly wisdom from above, to direct and guide us in all our consultations, and grant that we, having thy fear always before our eyes, and laying aside all private interest, prejudices, partial affections, the result of all our counsels may be to the glory of thy blessed name, the maintenance of true religion and justice, the safety, honor, and happiness of the Queen, the public weal, peace and tranquility of the island, and the uniting and knitting together of the hearts of all persons and the states within the same, in true Christian love and charity one towards another, through Jesus Christ our Lord. Amen.
Please be seated. This Honorable House now resumes its sitting. Call of the roll.
Mrs. Holness, Mr. Bartlett, Mr. Holness, Dr. Clark, Dr. Chang, Mr. Montague, Mr. Shaw, Mr. Samuda, Ms. Grange, Mrs. Williams, Mrs. Mallow Fort, Dr. Tufton, Mr. McKenzie, Mr. Chuck, Mr. Vaz, Mr. Warmington, Mr. Hutchinson, Mr. Charles, Mr. Green, Mr. Terlong, Ms. Smith, Mr. Main, Dr. Dunn, Mrs. Cuthbert Flynn, Mr. Morgan, Mr. Davis, Mr. Brown, Dr. Charles, Mr. Chin, Mr. Clark, Mr. Cousins, Ms. Crawford, Ms. Daly, Ms. Davis, Mr. Golding, Mr. Graham, Dr. Guy, Ms. Hamilton, Ms. Hannah, Mr. Henry Kitts, Mr. Henry, Mr. Hilton, Mr. Jackson, Mr. Lawrence, Ms. Lee, Mr. Miller, Ms. Morrison, Mrs. Nita Garvey, Mr. Paulwell, Mr. Phillips, Dr. Phillips, Mr. Robertson, Mr. Robinson, Mr. Sibbles, Mr. Slowly, Mrs. Vaz, Dr. Wheatley, Mr. Williams, Mr. Wilson, Mr. Witter, Mr. Wright.
Thank you. Members, just before we start, I just want to indicate that during last Tuesday's sitting of the House, Member Marlene Malahoo Fort, our Attorney General, slipped on the stairs just by my chair here and fell. I want to indicate clearly to all of Jamaica that she did not collapse and she did not faint, as was reported and speculated by many people. She sustained some injuries, which her doctors advised will take a little time to heal. I also gather that some persons who were watching the news report of the incident may have gained the impression that I did not care, because in my effort, my own effort, to avoid a commotion, I indicated to the member who was on the floor at the time, Member Brownberg, to proceed with her presentation. I want the public, as well as members of the Parliament, to be assured that I was aware that the AG was also trying not to have any commotion at all, and didn't want to draw any attention to herself, having fallen on the floor. And I recognize that, because had I fallen also, I wouldn't want to draw attention to myself on the floor. I also did not think it was fitting that any member of the media should try to or to photograph her in that state, because I too, like other ladies, would not want that. And so I just want to let everybody know she slipped, she's recuperating, she will be well, and as a Parliament we wish her a speedy recovery.
Madam Speaker, I wish to, at this point, also wish my colleague a restful period while she recuperates, and ask that we all keep her in our prayers. At this time, Madam Speaker, I ask for the suspension of standing orders in order to allow us to go directly to public business.
Members, the question... I'm sorry.
No, the opposition would like to join in the statements that both you and the Leader of Government Business have made in respect of the member from St. James West, and to hope that she has a speedy recovery.
Thank you, Member Hilton. Members, the question before the House is that there is a suspension of standing orders to allow us as a Parliament to move directly to the item public business. Those in favour? Those against? The ayes have it. Madam House Leader, public business.
Madam Speaker, we will have two speakers, and then I will conclude.
So I think we're starting with the
We are starting with the
debate
debate on the sexual harassment bill.
Thank you.
Thank you, Madam Speaker. More than 20 years ago, a sexual harassment survey of June-July 1999, conducted by the Ministry of Finance Industrial Relations Unit on behalf of the Committee Against Sexual Harassment at the Workplace, found that when asked whether they knew what constitutes sexual harassment, most respondents, 80%, answered positively. When asked to define sexual harassment, 61% made an attempt to provide the definition. Most of those who made the attempt correctly defined sexual harassment as unwelcome sexual advances. The survey went further and presented the respondents with 6 statements and asked them to decide whether or not each statement constituted a form of sexual harassment. The first statement was a request by supervisor to have sexual relations to consider promotion. 100% of the women said that that constitutes sexual harassment. Only 87% of the men agreed. The second statement was a pat on the buttocks by your peers. 89% of the women said that that constituted sexual harassment. 67% of men agreed. The third statement, repeated use in relation to you by your boss of the words honey, darling, sweetheart. 75% of women said that constitutes sexual harassment. Only 57% of men agreed. Display of pornographic materials at the workplace, 87% of women said that that constitutes sexual harassment. 67% of men agreed. Suggestive remarks, 92% of women said that that constitutes sexual harassment. 71% of men agreed. A casual pat on...
Just a minute. Members, there's a loud talking, and I'm hearing mumble all over. Please, the minister's on her feet.
Thank you, Madam Speaker. The final statement was a casual pat on the buttocks by your boss. 100% of the women said that that constituted sexual harassment. Only 89% of the men agreed. This survey that was done more than 20 years ago confirms that intuitively we know what sexual harassment is. That is unwelcome sexual advances towards a person by another person. Most of the respondents indicated that they could easily tell when sexual harassment is happening. By the results of the survey, the agreement on what constitutes sexual harassment is much more pronounced among women respondents than males. Sadly, then in those days, only few cases of sexual harassment were reported, and when they were reported, absolutely no action was taken to deal with the complaint. The implication is that victims of sexual harassment were not encouraged to report the offense, since the few reported ones had been neglected by the powers that be. Madam Speaker, no more. The Far-Reaching Sexual Harassment Protection and Prevention Act 2021, being taken through this Parliament by Honourable Minister Grange, Minister of Culture, Gender, Entertainment and Sports, seeks to give power to those who feel powerless against the powers that be. Not only will this law, once enacted, define what types of conduct constitute sexual harassment, it tells us what conduct is prohibited, what are the avenues to have our complaints heard, what is the legal duty on companies, other institutions, or schools, the education sector, as to how cases of sexual harassment are to be handled, and what measures, actions, and steps are to be taken when a case is reported. Madam Speaker, school is one of the primary places where society transmits its values. The education sector has a special responsibility to transmit the awareness to our students as to what constitutes sexual harassment, and to take special care to ensure that we have an environment that protects all our students from sexual harassment. I particularly call on our tertiary institutions to ensure they apprise themselves of this current legislation and that sexual harassment sensitization becomes embedded in the curriculum. In a bulletin to our school leaders, the Ministry of Education, Youth and Information called on administrators in educational and training institutions to take the necessary steps to eliminate incidents of sexual harassment. As the ministry, with the charge of developing young minds, we have a responsibility to develop policies to address sexual harassment, conduct workshops, training sessions with all teaching staff and other employees, ensure that the issue of sexual harassment is incorporated in the curriculum, put in place a complaint or grievance procedure or committee to handle reports of sexual harassment from students, protect against victimization and false accusations, and to ensure that the accuser and accused have an equal chance to be heard. Madam Speaker, governments have recognized that aside from being a violation of human rights, sexual harassment can hamper development. I am proud of the steps that this government is taking at this time to address this very important issue. Madam Speaker, the Ministry of Education, Youth and Information made written submission on the bill in July last year and November as well, and presented oral submissions on the bill. The Ministry's policy will apply to academic and non-academic staff in the schools. The Ministry is committed to maintaining a workplace in which members of staff and customers are free from any form of harassment, and in particular sexual harassment, as we recognize that this violates the dignity of the individual and the integrity of the organization. The Ministry acknowledges that a victim of sexual harassment can be a man or woman. The victim can be of the same sex as the harasser. The perpetrator can be a supervisor, co-worker, other employees, or non-employee who has a business relationship with the Ministry. All Ministry employees and our customers are responsible for taking reasonable and necessary action to prevent sexual harassment, and all members of staff of the Ministry are expected to contribute to an environment free of sexual harassment and are encouraged to report promptly any conduct that would be in violation of this policy. Action will be taken by the Ministry within the appropriate time frame. Retaliation against any individual who makes a complaint of a sexual harassment or cooperates in an investigation of such complaint is strictly prohibited. Staff members who violate this policy are subject to discipline up to and including termination in accordance with the public service regulations. Other lesser sanctions may be imposed depending on the circumstances. In light of the proposed legislative framework in relation to sexual harassment and the recommendations of the committee, the Ministry will now undertake an extensive review of our draft model sexual harassment policy that was developed prior to the proposed legislation. This is to ensure that the draft policy is compliant with the requirements of the bill. The review of the policy will ensure that there is inclusion of provisions in keeping with the bill with regards to definition of sexual harassment and the minimum requirement, the duty of an employer or persons in charge of an institution, the issuing of a policy statement concerning the prevention of sexual harassment, procedure for lodging a sexual harassment claim, and internal mechanism for treating with the claim. The Ministry notes that the legislation does not apply to children under the age of 16, but notes that the Child Care and Protection Act, the CCPA, provides some level of protection for children in this regard. It should be noted that the Ministry is currently reviewing the Child Care and Protection Act. This revision will examine gaps in this regard and make legislative amendments to address these where it is seen to be inadequate. Once the draft policy is reviewed in keeping with the legislation, the Ministry will undertake a system-wide consultation process with the relevant stakeholders, which include parents, students, teachers, principals, education officers, and staff of the Ministry. When approved, the policy will be published across the Ministry and education institutions with clear procedures for remedying breaches when they occur. The Ministry, Madam Speaker, has also embarked on other initiatives to include health and family life education, as well as the revision of the Ministry's draft National Safe School Policy to enhance provisions on bullying and harassment, among other areas of concern. The Health and Family Life curriculum has a module on sexual harassment, and this is being updated in alignment with the new sexual harassment bill, and will include a study of the bill and other legislation on this matter. This will be delivered, Madam Speaker, at the primary and secondary levels of the education system, with designated teachers who have been trained to do so in age-appropriate ways. Under the Spotlight Initiative, in partnership with United Nations Children's Fund, UNICEF, and United Nations Population Fund, UNFPA, NGOs have been contracted to develop a training program in gender-based violence for the ministry, for the officers, for the teachers, for guidance counselors, and the deans of discipline to build their capacity to treat with this matter at the school level and to act as trainer of trainers to build the capacity of other local stakeholders. Training will commence the last week in July for officers, and for the teachers, this will commence at the end of August. Further, Madam Speaker, the Education Jamaica Teaching Council Bill that is going through the various steps right now includes provisions that disqualify persons who have been convicted of a sexual offense from registration as a teacher or instructor, and requires persons to satisfy fitness to teach criteria throughout their professional career. It must also be noted that though the legislation on the issue of sexual harassment is not yet promulgated, some actions have already been taken to treat in this area. For example, the National Parenting Support Commission, an agency of the ministry, has been proactive, and all of its staff members have been sensitized and trained by the Bureau of Gender Affairs in the Ministry of Culture, Gender, Entertainment and Sport. Thanks to the Bureau for this useful training, and we encourage other ministries and agencies to utilize the training available at the Bureau. The National Parenting Support Commission has incorporated in its training for parent mentors a module on sexual harassment within the context of this new legislative framework. Currently, there are 30 parent mentors who will provide information and support to other parents in 150 schools and 30 communities. The content on the new sexual harassment framework will be embedded in existing parenting education sessions that will target 40,000 parents over the next 7 months. That's 40,000 parents over the next 7 months. Additionally, the Parenting Commission, in collaboration with the United Nations Children Fund and parenting partner Caribbean under the Spotlight Initiative, has developed a curriculum for parents. One of the units of the curriculum features sexual harassment and will be implemented in 5 parishes: Westmoreland, St. James, Kingston and St. Andrew, St. Thomas and Clarendon. Facilitators will be trained across several agencies to deliver the curriculum to parents in these 5 communities. Madam Speaker, the Ministry of Education, Youth and Information considers the prevention of sexual harassment in the workplace an important issue and has already started drafting plans to conduct those training sessions. Madam Speaker, we must be resolute. We must take these steps. I commend Minister Grange and her team and all those who took the time to have their voices heard in the Joint Select Committee. Our task now, Madam Speaker, is to begin the work required to ensure we have this needed culture change in our country, Jamaica, land we love. Thank you, Madam Speaker.
Madam Speaker, thank you, Minister Williams. Madam Speaker, may I ask for a suspension of this debate and for us to go to question and answers to allow Minister Tufton to take his questions, to answer questions. Thank you, Madam Speaker.
Members, the question is that we have a suspension of the debate at this point to allow the Minister of Health to answer questions in his name. So we're asking for suspension to go back to the agenda, to the item questions and answers to questions. Those in favor? House Leader?
Madam Speaker, could the Minister of Health and Wellness answer the question at number 2 under my name on the question paper?
Just before the Minister answers the questions. There are really no strangers at all in the House this evening. But when the member from St. Catherine, North Central's name was called, she was not in the House, and I see her here now. And I think I'm correct in saying that congratulations are in order. Because the member is no longer a member Natalie Nita, but I think she is member Natalie Nita Garvey. Member, I can only say we wish you well on the journey that you have now taken up, because like politics, it's a journey that you have to walk carefully and walk good. And it was also remiss of me at the start of Parliament not to welcome to the well of Parliament today former Senator Senator Barbara Blake. Hannah, welcome back, Mr. Senator. And now, Dr. Tufton.
Madam Speaker, I know it's not my place to say, but I feel a little neglected considering that she's my neighbor, political neighbor, and I was not invited. I didn't even know about it. But congrats nevertheless, and best wishes.
Inviting all who she wanted to. So we.
Madam Speaker, in response to question 2 on the list of questions, I rise to give responses. First question: is the Minister aware of the directive from the Ministry of Health and Wellness that the labs accredited by the GOJ to do COVID-19 tests have been advised to now only do tests for travelers or persons referred for testing from a doctor because of symptoms? Answer: the Ministry of Health and Wellness approves labs for COVID-19 testing. Accreditation is conducted by accreditation bodies such as JANAC, that is the Jamaica National Agency for Accreditation. B, for private labs which do COVID-19 be done on 1, asymptomatic persons who require the test results for travel purposes, that is to fulfill the immigration requirements of the receiving country, and 2, symptomatic persons whose tests have been ordered by a physician for determination of their health COVID-19 status. C, for private labs which do PCR tests, the initial agreement was that tests should be done on individuals who require COVID-19 tests for personal business, while the Ministry of Health and Wellness conducted COVID-19 testing on individuals for health surveillance reasons. This protocol is currently under review, and I must admit that these questions are dated, and I want to apologize to the member and to this House for that. Question 2, if the answer to 1 is in the affirmative, can the Minister say when this directive was issued? Answer: in terms of A, rapid antigen tests. Speak up. The directive for the use of the COVID-19 rapid antigen tests for symptomatic persons only was given at the introduction of these tests for use in Jamaica. This is in keeping with the recommendations of the WHO PAO, in collaboration with whom the tests were introduced in September 2020. Information regarding this directive was forwarded to all applicants for public-private partnership SARS-CoV-2 testing. B, COVID-19 rapid antigen tests are lab tests, and like all lab tests, need to be ordered by a physician to whom the test results are to be returned. Information regarding the relevant protocol was sent to all applicants for public-private partnerships for this particular test, SARS-CoV-2 testing, and was included in the 6th schedule of the Disaster Risk Management Act. and the date of that act is stated here, and that has continued. C, in January 2021, at the commencement of private sector rapid antigen testing to meet the requirements for international travel, the Ministry donated supplies for rapid antigen testing to private labs, which were to offer these tests to visitors and residents. The documentation presented to the private labs at that time included the attached testing algorithm, Appendix 1, which clearly outlines the categories of persons to be tested and all required reporting and confirmatory tests. This documentation is routinely given to labs approved for this particular rapid antigen test. And B, for the PCR test, this directive was issued at the start of the public-private partnership for PCR tests and involved Carigen only. This is an entity that is private but operates out of the University Hospital of the West Indies, as Carigen was at that time the only private lab with PCR testing capacity for this particular SARS-CoV-2 test here in Jamaica. And then question 3, if the answer to 1 is in the affirmative, can the Minister say what is the rationale for this? Answer A, as it relates to rapid antigen tests, use of the rapid antigen test on symptomatic patients only is based on the sensitivity and specificity of the test. Due to the reduced sensitivity of the rapid antigen test with respect to PCR tests, false negative results are possible with the antigen test. Negative tests in symptomatic persons are therefore considered as preliminary results, and samples from these patients are sent for confirmatory PCR testing. The percentage of, and this is B, the percentage of false negatives increases if COVID-19 rapid antigen tests are used as asymptomatic patients, on asymptomatic patients, and consequently antigen tests are not recommended for use on these persons. And then B, re-PCR tests, the directive to private labs to conduct tests on persons requiring COVID-19 status for personal reasons are based on 1, the protocol of the Ministry to conduct all public health testing in order to contain the spread of COVID-19 in Jamaica, and 2, the inability of the Ministry to offer routine tests to persons requiring COVID-19 status for personal business, including educational purposes and personal travel, due to the limitations of the public sector lab capacity, and 3, the fact that the PCR test for COVID-19 was initially the only approved methodology for the diagnosis of SARS-CoV-2 infection in Jamaica. 4, the limited private lab capacity for PCR COVID-2 testing in Jamaica at a given time was also an issue. And as previously stated, this position directed by the Ministry is currently under review given the increased capacity of private labs within Jamaica to conduct PCR testing, and not much has changed since that time, Madam Speaker. We have had other labs coming on board. The fact that Jamaica is now experiencing community spread of COVID-19 with a consequent large increase in the overall number of cases, as well as the number of persons who are interested in seeking private medical services, including PCR testing. Question 4, if the answer to 1 is in the affirmative, can the Minister state what international health authority standard guides this decision? Answer, Jamaica is guided in the use of COVID-19 rapid antigen tests by the recommendations of the WHO PAHO, which state that they are to be used for symptomatic persons only. B, the decision to allow COVID-19 rapid antigen testing of asymptomatic persons for the immigration purposes is based on the immigration requirements of receiving countries. And question 5, can the Minister state what happens to persons who are exposed by contact and without symptoms and who want to know his or her infection status? Answer, contacts on risk assessment who are deemed to be close contacts of a COVID-19 infected person are tested as part of the contact tracing activity. A PCR test would be done for asymptomatic persons. Rapid antigen tests are not approved, not suitable for use with asymptomatic persons as a result of their decreased sensitivity in that population, which reduces the predictive value of those tests. Question 6, can the Minister say whether this new measure will affect the number reported on a daily basis, as the asymptomatic positives will not be captured in the Ministry's data? Answer A, private labs have been asked to report daily to the Ministry, and consequently asymptomatic positives are captured on a daily basis in the Ministry's data. And B, all positive cases, PCR and antigen for both symptomatic and asymptomatic persons are counted daily in the confirmed COVID-19 numbers. And the final question, Madam Speaker, question 7, can the Minister say how this will affect the positivity rate? Answer, the antigen test has a low sensitivity, especially among persons who are asymptomatic, and has high false negative rates. Therefore, the numerator would be smaller by using the antigen test alone, and the positivity rate would be lower than the truth. Given this, the Ministry, in addition, reports a corrected positivity rate, which includes PCR tests from the public and private sector, as well as antigen tests from the public sector. The approach for antigen testing in the public sector involves conducting PCR tests on the sample that tests negative by antigen. Thank you, Madam Speaker. And as I said, Madam Speaker, these questions are a bit dated because they should have been answered some time ago. So.
Thank you very much, Madam Speaker. The point made by the Minister is that these questions are very dated, and the truth is that many of the recommendations that are outlined here are actually have actually changed over a period of time. There is, however, Minister, a question that a follow-up that I'd like to ask. That's on page 2, as it relates to question 2. Was that original directive as to what samples that could be tested, was it as a consequence of the donated test kits that was given to the private sector from the government amounts? Secondly, there is an inconsistency in your argument that is found under question 3. And if you flip the page, you said, as previously stated, this position/directive by the Ministry of Health and Wellness is currently under view, given, and I go to B, the fact that Jamaica is now experiencing community spread. Now, these questions were asked in April, and it was in September, in fact, September 2, 2020, that the government announced that we were in community spread. So I would have thought that having been seized with that particular knowledge, that particular position would have changed much earlier and not under review for change. Minister, I want to thank you for these answers. But when we are where we are now, and these questions, as you correctly and I have indicated, are dated, and we are seeing a situation in this country where the number of positive cases have been coming down. The positivity rate has consistently over the past couple of weeks been under 11-12%. We have seen where the number of cases in the hospitalized cases have been decreasing, though on some days we see where the critical numbers have been going up. But what is strange about all of this, Minister, is that the number of deaths have been increasing. And what we have seen over the past 3 to 4 weeks is a weekly fatality rate of about 8 to 10%. Even when you take those numbers that were previously under investigation, we get them at 8 to 10%. And at the height of this spike that we had in March, April of this year, the weekly fatality rate was under 1%, was 0.6, 0.8, 0.87. We are seeing now where we are having 8 to 10% fatality rate each week. So 8 of every 10 persons, 8 to 10 persons of the numbers that we see on a weekly basis are dying. And the question that needs to be asked is, what is happening in the public health sector? Why is it that we are seeing now more deaths per number of patients positive than we saw earlier on? What has changed? What has changed in terms of the medical management of these cases? And, Minister, I think also the other part that needs to be investigated, whether is that we are having, even in the absence of any confirmation whether the Delta variant is here. We have been told that test samples are now not only sent to CARFA, that they are being sent to PAHO labs in Brazil and Mexico and to CDC, and we are expecting the results to come back. But the reality is that we are seeing more deaths, and that demands an answer from the government as to what is happening in the care of these COVID cases. The other thing to minister is that I made a suggestion at the last COVID meeting that we had that the government needs, the ministry needs to change its surveillance method. The technocrats replied by saying that nothing will change, nothing has changed. But the reality, and my suggestion was based on the fact that we are seeing lower numbers, we're having these deaths, so we ought not to have so many deaths. Are we not capturing the number of cases that are actually out there? And I made a suggestion that probably what should happen is to do some random samples in communities so that we could see whether it conforms with what the ministry is saying that they find at the public health institutions. Because right now the samples are only collected from persons who present with acute respiratory syndrome at the hospitals and health centers, and then the tests are done. The point is, Minister, the point is that many persons may have the COVID-19, but the science is telling us that COVID-19, the Delta variant, is not presenting in terms of symptoms as was the original strain, nor even the beta strain. The reality is that most of the presentation now is looking like an ordinary cough and cold or a flu. And it is for those reasons why it is very important for the government and by extension the country to have a handle on where we are with this. Added to that, our vaccination program, albeit very, very slow off the blocks, and in terms of the numbers that have been vaccinated, hardly any persons below the age of 50 have been vaccinated fully or even one dose. But we see where Delta is affecting persons below the age of 50, inclusive of children. So, on the one hand, we need to know whether it's here. On the other hand, we need to know the extent of, if it's here, to what extent it's here. And thirdly, we need to have an answer as to why the death rate is so high. Because if we continue at this rate, Minister, what will happen is that we'll end up in a situation where the death rate exceeds what is happening internationally in terms of the number of COVID cases. And my final comment, Minister, was that at one of the Prime Minister's statements, and in responding to it, I asked about what is the excess death in this country. And the excess death, Madam Speaker, is the number of persons who have died in a particular period compared to another period. And in this period, we're talking about the COVID period. The Prime Minister indicated that they have that number. But he has only indicated that the number is there, but has not said what that number is, nor has the country been told what the number is. Do we have an excess death? Last year, around this time, I spoke about it, and I made reference to the Russian experience, and it was called the Russian roulette then. But we have had 12 months more of COVID infection, and we need now to know, the country needs now to know whether, Minister, we have, and what is the excess death in this country now. It will give us a handle as to how many persons would have died and purported to die from COVID vis-a-vis the actual confirmation from COVID. Thank you.
Madam Speaker, as I listen to the member from St. Mary's Central on the deaths, I just want to ask the Minister a simple question. The persons who have died, over 1,000, literally 70, certainly over 70, maybe 80% of them are over 60 years of age. The question I would really like to ask, how many of them actually were vaccinated? Maybe the Minister doesn't have, but it would be an interesting indication, Madam Speaker, whether those over 60, because they were supposed to have been vaccinated under the Blitz and so on, just how many of them actually had the vaccination, were vaccinated and actually died, and since January. And the truth, Madam Speaker, is that as one who likes numbers, I've been looking at the numbers, and there's no doubt that our death rate is definitely within the international norm of about 2.1% overall. So internationally we're at about 2.1, but I'm more interested to find out how many of these individuals have avoided vaccination and unfortunately have succumbed to the COVID. Thanks, Madam Speaker.
Madam Speaker, let me thank the members for their observations and questions. Again, I agree and have accepted that the answers are a bit dated, and so there will be some need for for some updates. So let me just run through quickly on the issue of the community spread and the reference to community spread. Remember now, member and colleagues, the management of the pandemic over the last 15 months, 14 months or so, would have seen more and less of that taking place. So the extent to which we respond is a function of what is happening at that particular point in time. So while community spread would have started before, there is a point when it was not as, based on positivity rates, when it was not as intense, and therefore the response would vary. So it's a moving target, and therefore one would understand why the urgency may be more at one point as opposed to another. And in the case of engaging the private labs, there was a need at the time for us to have more testing done. The capacity for testing was limited. The member may recall that we had gone into a training session in collaboration with PAHO to bring these labs up to speed. And upon completion, frankly speaking, many of them did not make the necessary arrangements to access the testing materials, and we took a decision as government in the interest of the populace and the need for expanded testing to make the kits available. And that was seen as a public good for the overall protection of the population. And I think that was a good decision on the part of the public health team. The issues around deaths, member, is an important one to raise from at least one perspective. And that is to remind the country, Madam Speaker, of the seriousness of this virus. Because there is a tendency, particularly when there is some relaxation, for persons to view the challenge or the risk at hand as being not as severe. So I am happy the member has raised it, even though he raised it in another context, to question what is the reason for it. I want to say that it is important that all Jamaicans recognize that this virus can kill you still, and we should ensure that the protocols are observed. Now, there are two possible explanations for the deaths, and the deaths are concerning to the public health team. This is something I've discussed with them. We have reported to Cabinet on it. Firstly, a part of the increased numbers are the cleared-up rates of deaths that had taken place long before and then had to be interrogated, or the circumstances, the follow-up, and then the team would rule on whether COVID was the cause of death or otherwise. And so some of those numbers are historical. even though they may be reported on a particular day. I can't give you the breakout, but that has accounted for some of that. The other, which is a worrying trend, and the country should take note on, is the fact that we are seeing increasingly late presentations to medical institutions for treatment of persons who have contracted or who are carrying the virus. In other words, and it's not unusual to Jamaica, we are seeing persons who have symptoms and who try to self-medicate and to find their own solutions for one reason or the other, and end up at the hospital when they are in an advanced state of illness. And that is unwise, and I think that has contributed also to the severity of the cases in hospitals and, by extension, the ultimate consequence of death. In the early stages, there was a fear, and we had persons wanting to make sure, even with a little sniffle. Now, persons feel like they can manage, and we want to use the opportunity to advise all of Jamaica that if you are unclear as to your condition, seek medical attention, get tested. The system allows for that. Your doctor at least will give some guidance on that. But that, I think, has explained some of the high numbers. But nevertheless, it is concerning to us, and I want to take that point from the member. The issue of the variant strain, and in particular the Delta strain. Only yesterday we reported to Cabinet on tests that we got back late last week. And the member is correct. We did say that we have 3 locations that we send samples to, and we had committed that each week we would send out 100 or so samples at one of the 3 locations for testing to carry out the surveillance on whether the variant strain or the Delta strain in particular is here. The results we got last week, and there would be a 2-week lag based on the time it takes to get the results, suggest that, well, we did not find the Delta strain in those results. I think we got back just about 60 or so results. But each week we will continue to report based on those results. I will say, though, that I think with time...
Minister, could you yield a little? Madam Speaker, Minister, can you advise as to when the date of origin of those samples? Because that's important, you know?
Right. So I did say that we're looking at a 2-week lag between when it is sent and when we get the results. So the ones that we would have gotten last week would have been a few weeks before. I can't give you the specific date.
Oh, I was actually referring to when the samples were actually done, not when they were sent off, when they were done.
When they were done?
When they were taken.
Oh, I need to check on that. But 2 weeks after delivery, we get the results in this instance. We should not be complacent, however, because we do believe that it's a matter of time before the Delta strain gets here, given that it is now the dominant strain in certain countries, including our main trading partners. And I think it's something that the country should be seized with. But we have not found evidence of it as yet. On the issue of surveillance and the testing, we see our role in the current dispensation, public health that is, as doing surveillance to determine what is happening in the environment and to provide the advice to the Cabinet, to the country, and of course from there decisions are taken. And I think the team has been doing that. And if there are issues that are specific beyond what is already public, then we will at some point make that information available. The vaccines for 50s and over, it's not correct to say persons under 50 have not received vaccines. I can't give you the numbers. What did you say?
I said the vast majority who have received vaccines are over the age of 50. There have been a few under 50, whether fully or partially vaccinated.
Right. So I'm not even prepared to say a few. It probably would be more than a few, because we did have a 83,000 vaccination blitz over 4 days, which was open to everyone. And they are entitled to get their second dose once they are due. So it's not our single dose. We did not discriminate by by age in the initial period for second doses. Well, actually, we have not discriminated at all. Once you got your first dose and you're due your second, we have applied that. And then the issue of but I think that's it. I don't recall any other question. Thank you very much, Madam.
House Leader.
Thank you, Madam Speaker. I now ask for recommittal to go back to public business, where we will continue the debate on the sexual harassment bill. Thank you.
Members, again, we're asking for the standing orders to be suspended to enable us to return to the item public business. Those in favor? Aye. Those against? The ayes have it. We'll continue the debate. Member Chuck, you are standing.
Madam Speaker, as a member of the committee on the Joint Select on the sexual harassment bill, it would be remiss of me not to say a few words. I was reluctant, Madam Speaker, because I have a natural tendency to chuckle as a pause. So I have to be very careful when I speak on sensitive matters like this, lest I be accused of being insensitive. Madam Speaker, may I say I want to congratulate the Minister Grange for the manner in which he conducted the Joint Select Committee and for the many contributions that were made, most of which were considered fully. And we have a fulsome report which was considered by the members of the committee, and also the bill itself, which I think should reflect a good sexual harassment bill. Madam Speaker, this bill should send the right signal across the country that we need to treat our women, the weak and vulnerable sex amongst us, in a very decent and dignified manner. Well, the vulnerable sex. So, Madam Speaker, what has happened in this country, the women of our country have been the backbone in virtually every area of life. And, you know, Madam Speaker, it is even more obvious in the political sphere. When you campaign, when you deal and you go into the communities, and when you want things done, it is a woman you depend on. The men are basically interested in Guinness and beer. But the women are the ones you depend on to get things done. In truth, Madam Speaker, in truth, Madam Speaker, we must send a signal in this sexual harassment bill that we need to treat our women properly and appropriately at every sphere of life. And Madam Speaker, I hope that a few cases will come to the tribunal, and hopefully when they are assessed it can send the right signal in terms of how we balance. Because in truth, Madam Speaker, we need to balance carefully and appropriately. Because yes, Madam Speaker, I have no doubt that there's a fair amount of sexual harassment at the workplace when tenants need to get places for accommodation. Landlords utilize their power and the knowledge that they have somewhere for the tenant to get and abuse the women, sexually abuse the women who need these places for accommodation. We get the sexual harassment, Madam Speaker, in many institutions. And this bill, Madam Speaker, must send a signal that these harassment must stop. And many of the harassers, Madam Speaker, are also engaged in abuse. And you find that a lot of the domestic abuses may well come from these sexual harassers. So this, hopefully, Madam Speaker, will also stop the abuses which occur in many homes and many communities. Madam Speaker, as I say, we need to find the right balance. And sure, Madam Speaker, there's no reason why any employer or any man should be slapping a woman on her bottom or on her chest. So that is the extreme. But we cannot ignore, Madam Speaker, where an affectionate touch on the shoulder or on the elbow or a squeeze of the hand is deemed to be sexual harassment. So we have to be careful in finding the balance between an affectionate touch and an inappropriate slap. And Madam Speaker, this is where the tribunal will have great difficulty in how it balances the complaints that come before it. Madam Speaker, there are many examples that one could use that are different extremes, and how the tribunal will balance is really a challenge for them. So, Madam Speaker, in supporting this bill, I strongly urge employers, I strongly urge the ministry to advertise and ensure that at the end of the day, this bill has teeth and that all women are properly protected in this country. Thank you, Madam Speaker.
So we can go.
Madam Speaker, for the avoidance of any doubt, the opposition is fully supporting this crucial bill. I hope it will lead to a more productive and safe working environment. It is by no means a perfect bill, but a giant step in the right direction. Madam Speaker, we understand sexual harassment as unwelcome sexual advances, requests, favors, or other unwelcome conduct of a sexual nature that can be offensive and make one feel intimidated or humiliated. This can happen on its own or in conjunction with other forms of discrimination. This unwanted behavior can be spoken, written, or otherwise expressed abuse. The bill, Madam Speaker, is not a panacea to address what is an increasing problem in the Jamaican workplace and other institutions covered in this bill. Still, it offers hope to victims that their complaints will be redressed. Madam Speaker, under normal circumstances, the average adult will spend 1/3 of their life at work. This is equivalent to approximately 90,000 hours within the work environment. Given the significant amount of time we spend with our workspaces, it would be safe to conclude that our work environments plays a role in the quality of life that we experience. In our work environment, we spend a lot of our time socializing to enrich our life experiences. Still, this engagement, when not used appropriately, brings us to the decadence of sexual harassment. When we interact with each other inappropriately or wrongfully, it recreates a series of negative consequences, including sexual harassment, which has become the focus of debates today. Madam Speaker, the effects of sexual harassment have served
Madam Speaker, the effects of sexual harassment have severe implications on employees' physical and mental health and the overall productivity within the workforce. In fact, a study by the University of Pittsburgh showed that women exposed to sexual harassment were 3 times more at risk of developing depressive symptoms. In addition, these women also experience stress reactions, high blood pressure, and lower self-esteem. Deloitte Access Economics, an economic advisory company, conducted a study in Australia to estimate the economic costs of sexual harassment in the workplace. In Australia in 2018, this study highlighted that workplace sexual harassment resulted in a loss of productivity of approximately 2.6 billion Australian dollars. In Jamaica, research has shown that productivity levels are declining. For example, in the 2000 to 2019 period, Jamaica experienced a 15% decline in productivity compared to a 51% increase in countries like the Dominican Republic. Madam Speaker, although there is no data locally to show how sexual harassment affects productivity, there are interlinkages between productivity and safe working environments based on international studies. Therefore, I am happy that the government has prioritized passing this bill into law. Commendations should be given to a number of ministers, ending with Honourable Minister Grange, number of the Joint Select Committee, and those individuals and organizations who made submissions on the draft bill. So many have struggled with this over many years. Where we are today is evidence that the hard work and collective efforts of all have not gone unnoticed. However, I believe more needs to be done to strengthen the provisions of this bill. I therefore putting forward the following recommendations. Madam Speaker, I believe that there is a need for the legislation to mandate employers to provide on-the-job sexual harassment prevention, exposure, and especially on the provisions of the bill. This is needed to promote increased awareness within the workplace about recognizing sexual harassment and sensitizing employees to what constitutes a sexual harassment offense and the damage it causes within the working environment. Section 4 of the bill speaks only to the duty of employers to issue a public statement in writing concerning the prevention of sexual harassment in institutions. Madam Speaker, we have to consider our own culture, just as the Minister of Justice alluded to, which has normalized some inappropriate behavior. That is why we think that it is important for employers to provide sexual harassment prevention training on the job. Secondly, the first schedule of the bill speaks about protection against retaliation. However, does the proposed bill provide adequate mechanisms that protect victims from retaliation or wrongful termination if a sexual harassment claim is filed? Madam Speaker, as legislators, we must carefully examine the bill to ensure that the appropriate legislative remedy is in place, whether in the legislation or subsidiary legislation, to protect victims from unintended consequences that can arise from filing a sexual harassment claim. In the Joint Select Committee report, there was a proposal to create a standalone victimization provision that can be advanced through the tribunal. This would empower the tribunal to make a financial award for such a breach or authorize the parish court to award the victim. However, I note in reading the report that the Joint Select Committee did not accept this suggestion. I am therefore recommending that a clause be inserted to give effect to this recommendation, as we must do everything in our power to protect victims from sexual harassment. Thirdly, in reviewing Section 5, subsection 2A of the bill, I want to bring to the attention of this Honourable House that the provision of this section states that an employer should notify the worker in writing or electronically within 2 days of receipt of a sexual harassment claim. Madam Speaker, what if someone reports a harassment claim on a Friday? Should the employer be obligated to notify the employee on a weekend day that their claim was received? I do not believe that this was the intent. Madam Speaker, I am recommending that the wording of the provision be amended to state 2 clear days instead of 2 days. This provides a reasonable time frame for employers to acknowledge workers' claims that have taken appropriate action. Madam Speaker, a similar amendment would also be needed in Section 6, subsection 2A. Fourthly, I want to bring to your attention that there is a silent epidemic happening in Jamaica. In 2018 situation analysis on persons with disabilities in Jamaica, the report highlighted that persons living with disabilities are more likely to become victims of physical and sexual abuse. Madam Speaker, it is therefore important that our laws have adequate provisions that protect and promote the right of all citizens, especially those persons living with disabilities. Therefore, again, before this bill is passed into law, we must do everything in our power to ensure that the disabled community is not disadvantaged by any provisions within this law, and that this legislation reflects the standards within the Disabilities Act of 2014. Madam Speaker, this is important because the government has committed to transforming the lives of people living with disabilities, which is reflected in our National Development Plan, Vision 2030. In addition, Jamaica has obligations under international commitments with regards to the rights of persons with disabilities, which are enshrined within the UN Convention on the Rights of Persons with Disabilities. Fifthly, in preparing for my presentation today, I reviewed both the draft bill of 2015 and the draft 2021 bill that is now before this Honourable House today. I want to ask the government to explain the rationale behind setting up of a separate tribunal to hear sexual harassment cases. Madam Speaker, why can't existing mechanisms be used to achieve the desired outcome? When we were in power, the draft Sexual Harassment Bill of 2015, which was brought before this Honourable House, made provisions for victims of sexual harassment to make complaints to a sexual harassment division under the Industrial Disputes Tribunal. This division was empowered to hear sexual harassment cases between an employer and a worker. Additionally, complaints involving institutions could also be brought before the resident magistrates' court, acting in civil jurisdiction. Madam Speaker, I am asking the government to utilise a similar mechanism as proposed in the Sexual Harassment Bill of 2015. My final recommendation is centred around the need for a comprehensive monitoring and evaluation framework for the sexual harassment workplace policy. Madam Speaker, the Honourable Minister told this Honourable House that an earlier review period was needed for the bill to evaluate the efficacy of the systems and structures that will be involved in the use of this legislation. Accordingly, I am in full support of the proposed time frame of 18 months for the review of the bill. However, I would also like to use this opportunity to implore the government to implement appropriate monitoring structures to ensure that the data collected from different organizations or institutions is used efficiently to guide our policy responses. Therefore, this Parliament can ensure that interventions are implemented to mitigate sexual harassment in the workplace and other institutions as stipulated in this bill whenever the need arises. Madam Speaker, may it please you.
Thank you very much, Madam Speaker. Three quick questions for the Minister of Education. Minister, I heard you make mention of about 8 different parishes, but nothing was said about St. Catherine in terms of the targeted ones.
Member Daly, we had actually passed, she made a statement in her contribution to the debate that is before us. So it's the debate that we're actually doing. I thought you were participating in the debate. I'm so sorry. Leader, over to you.
Madam Speaker, I wish to thank all those who made their contributions to the debate on the bill entitled the Sexual Harassment Protection and Prevention Act 2021. This piece of legislation is not partial to any gender because sexual harassment is not biased in its violation. Men and women have too often unhappily recounted experiences of sexual harassment against them. It is against this background that the bill before the House is gender neutral and seeks to protect and prevent sexual harassment against both men and women. Madam Speaker, you will recall that last week the old sexual harassment bill was withdrawn and a new one was tabled in its place. This new bill, properly titled the Sexual Harassment Protection and Prevention Act 2021, incorporates all the recommendations emanating from the Joint Select Committee appointed to consider the bill. This bill is therefore new and improved. These improvements, Madam Speaker, have birthed a more robust legislation. Last week, I brought to our consciousness some of the improvements in the bill to include the fit and proper person criteria, the institution of a sexual harassment policy statement within 12 months, the widening of the categories that can be sexually harassed, the limitation of action and the review period of 18 months. In addition to these improvements, Madam Speaker, I wish to highlight some additional ones. Clause 7 of the bill directly addresses the procedure to be employed when an allegation of sexual harassment involves an employer or a person in charge of an institution. Clause 7 reads, notwithstanding the provisions of Section 27(4), where an allegation of sexual harassment is made against an employer or a person who is in charge of an institution, the worker, client, or student, resident, ward, inmate, patient, or member, as the case may be, may make a complaint directly to the tribunal. It is important to note, Madam Speaker, that Clause 27(4) of the bill mandates the use of internal complaint mechanisms before a matter progresses to tribunal stage. However, Clause 7 overrides the proviso in 27(4) to protect a potential complainant. Many complainants have often expressed fear where sexual harassment is meted out to them by their supervisor. The requirement to use internal mechanisms as a first point of complaint would undoubtedly greatly expose such a person to undue prejudice. It is this situation which Clause 7 seeks to prevent. Thus, where an allegation of sexual harassment directly involves an employer or the person in charge of an institution, such a complaint should be made directly to the tribunal in keeping with the tribunal's processes and procedures. Clause 8 of the bill requires employers or persons in charge of institutions to keep a confidential register. Madam Speaker, some might question the need for this inclusion. It cannot be ignored that some workplaces and institutions opt not to record complaints of sexual harassment, but to treat it instead as purely a verbal complaint. The consequence of this is usually that complainants lose interest and integrity in the process. Madam Speaker, the maintaining of a confidential register is a requirement on employers and persons in charge of institutions. This confidential register will also serve the tribunal well in instances where the tribunal, in considering a complaint, requests to see the details relating to a particular complaint of sexual harassment. The information to be contained in the confidential register include A, the name of the parties to the sexual harassment claim, B, the particulars of the sexual harassment claim, C, the date on which the sexual harassment claim was lodged, D, any action taken by the employer or person in charge of an institution in relation to the sexual harassment claim, and E, such other particulars relating to the sexual harassment claim as may be prescribed. An employer and person in charge of an institution shall ensure that the information contained in the register is kept in a secure manner and that the confidentiality of the information is preserved, and shall A, take all necessary and appropriate measures to protect the information contained in the register from unauthorized access, unauthorized use, and unauthorized disclosure. And B, ensure that any person who has access to the register adheres to the measures referred to in paragraph A at all times. No person shall disclose information which is recorded in the register in relation to a sexual harassment claim unless the disclosure is made with lawful authority. Madam Speaker, this bill seeks to protect and prevent sexual harassment in not only workplaces and institutions, but also in accommodations, be they residential or business accommodations. Therefore, Madam Speaker, the landlord and tenant relationship is captured in Clause 11 of the bill. Importantly, Madam Speaker, any person who has a complaint emanating from Clause 11 has to make that complaint directly to the tribunal. In this vein, Clause 11 must be read in tandem with Clause 15A3. Clause 15A3 grounds the tribunal's jurisdiction to hear and determine complaints made under Clause 11. Clause 15A3 says, subject to the provisions of this part, the tribunal shall have jurisdiction to hear and determine 3. A complaint made by a person in relation to a matter arising under Section 4, 4, 7, 9, 10, 11, or 27, 1D. Clause 12 speaks to authorized officers who will be field officers attached to the Bureau of Gender Affairs, who shall secure the proper observance of Clause 3 and 4 of the bill. The authorized officers under the new bill, Madam Speaker, will solely be empowered to effect compliance to clause 3 and 4 of the bill. To this end, those officers, for the purposes of carrying out their functions, may 5A, with a warrant, enter any place of employment or institution in order to ascertain whether the provisions of sections 3 and 4 are being complied with. B, inspect any place of employment or institution to ensure compliance with the provisions of section 3 and 4, or A, inspect and take copies of documents and other information, or require any person at a place of employment or an institution to provide such information as may be reasonably required for the enforcement of the provisions of this Act. Madam Speaker, I just want to thank all those who have made contributions and to indicate that because this legislation will be reviewed in 18 months, we will have an opportunity to take into consideration some of the matters that were raised during the contributions here today. And that at this point, I just want to thank everyone and to thank the technical team that has assisted in this groundbreaking piece of legislation, and to indicate that I'm happy that both genders in this chamber supported the bill, and that I think as a legislature we have not only indicated that we want to do something, but we have acted in doing so. So Jamaica today is a better place for your contributions. Madam Speaker, at this time I ask that the bill be read a second time.
Members, the question is that the bill, the Sexual Harassment, Protection and Prevention Act 2021, be now read a second time. Those in favor? Aye. Those against? The ayes have it.
A bill entitled An Act to Make Provision for the Prevention of Sexual Harassment and for Connected Matters, read a second time.
The House will now resolve itself into a committee of the whole House to consider the bill clause by clause. Members, I put part 1, clauses 1 to 2. Those in favor?
Madam Speaker?
Yes.
Clause 1A, clause 2 in the definition of the word worker. Move paragraph B back to the margin. That's on page 4. That's an amendment to clause 1.
So there's an amendment. What's the amendment? Can you do that again? What's the amendment to clause?
So the amendment to clause 1, 1A, clause 2, in the definition of the word worker, move paragraph B back to the margin.
Okay. All right. Those in favor? Those against?
Madam Chairman, so there's also a list of amendments, including an amendment to Clause 1, which is the actual short title of the bill. The bill as tabled, I think, was in the old name, and there's a proposed amendment, according to this sheet which was handed out, so that the bill is actually supposed to be entitled the Sexual Harassment, Protection and Prevention Act 2021. So that ought to be approved as an amendment as well.
Yes, member. At the end, I was going to put the title and the enacting
yes,
clause,
at the
so
end,
it will be included.
Didn't you put
actually,
clause 1?
Clause 1 has it in all. Clause 1 has it. It's just in the cover.
Yeah.
Yes.
Yeah.
So would you like for us to now do it at this point? Is this what you're asking? Very well. Minister?
Okay. Remember, the title and enactment clause is a long title, you know, but this is an actual clause in the bill.
So in fact, there are 2 amendments then to clause 1. Is that it?
Clause 1 is okay, Madam Speaker. It is the short title.
Put the title and enacting clause at the end.
Okay,
yes.
Very well.
Yes.
I'm not hearing you. Can you turn on your mic? And I have spoken with the clerk, and they've had somebody in to check it, but I think that although it's been checked, it's aging fastly. Fast.
Madam Speaker, I understand they're actually working on it now.
It happens ever so often, Member Hannah. I think it's coming to its end of its days because they have been working.
No, it malfunctions every Tuesday at 2 o'clock.
I think what happens is that it is being worked on right now, but it happens almost really very often, and I do think that it's coming to its end of its days. As we get older, all sorts of things happen, and I think that's what's happening with it.
Madam Speaker, with your permission, with all due respect, the Parliament is the Parliament.
Absolutely.
And we must get professional persons who can assess, diagnose the problem, and prescribe an intervention that can resolve it once and for all with a sense of urgency. The conditions is to discourage members from coming.
That's correct.
And one may want to construe that might be an intention.
Madam Chair, I agree with you, but we are going on a break soon, and I know that the concerns are there, and I know that the clerk intends to use the break to deal with the matter, because some issues jump out that didn't turn up last week. As I say, as you're aging, different things crop up. But I know during the break the matter will be addressed.
Madam Chair, I know some of us are very hot, but this topic is also a hot topic. So if we could proceed, if you don't mind, Madam.
We are going to get out as quickly as we can and move on. But I do understand the discomfort, and be assured it's going to be addressed properly.
Go through this as quickly as we can, right, Madam Chair?
You're right.
Yeah.
So now we are at part 2, clauses 3 to 8. Minister.
Madam Speaker, clause Clause 7. No, that's fine, Madam Speaker, yes.
I now put clauses 3 to 8 with the amendment to clause 7. Those in favor?
Aye.
Those against? The ayes have it. I now put part 3, clauses 9 to 11.
Subclause 9b, move the words are contingent on the person's acceptance of or submission to sexual advances from the prospective employer, back to margin.
Members, I now put clauses 9 to 11 with an amendment to clause 9b as stated by the minister. Those in favor? Those against? The ayes have it. I now put clause 5, clause 12, clause 12. Those in favor? Those against? The ayes have it. I now put clause 5, clauses 13 to 26. Those in favor? Those against? The ayes have it. There is? Yes. There's a
15 substitution.
Yes, we're there.
Clause
13 to 26.
Clause 15 needs and
15 paragraph
4.4.
Paragraph 4.4. Paragraph 8.3. Delete 4.4 and substitute 4.5. And insert after 4.5 the following 5.2.
Right. And
Members,
also,
I now put clauses 27 to 38 with two
Madam
amendments.
Speaker, clause 22 also. Clause 22 also.
Yes, clause 22, delete 19 and substitute 21.
21, right.
I now put clauses 27 to 38 with 3 amendments. Those in favor?
Aye.
Those against? I now put clause 39 to 41. Those in favor?
Madam Speaker?
There's an amendment.
Clause 13, paragraph B, if we could move the words of the facts and reasons for its finding, and the tribunal shall take no further action in relation to the complaint back to margin.
That's fine.
That also needs to be amended.
So that I put clauses 39 to 41 with 1 amendment. Those in favor?
Aye.
Those against? The ayes have it. I now put clauses 42 to 46. Amendment
42 to 46, Madam Speaker, fine, go ahead. No amendment. No amendment.
No amendment. Those in favor?
Madam Speaker, 46 actually has 44, it should be 46 on page 29. Look at page 29, Madam Speaker. It says 44, but it should be 46, I suspect.
That's an amendment. That's a typographical error?
That is typographical,
right.
Yes.
So, I now put clauses 42 to 46. Those in favor?
Aye.
Those against it? Against? The ayes have it. I now put the schedule. Those in favor? Those against?
Aye.
I put the title and the enacting clause. Those in favor?
Aye.
Those against? The ayes have it. So we have, am I correct, 9 amendments? 10? You have 10. How many amendments do you have? 10? Have you counted? I just want to make 10. That I do report the bill as having passed committee stage with 10 amendments. Those in favor? Aye. Those against? The ayes have it. Members, I report the bill as having passed committee stage with 10 amendments. Minister, your turn.
Madam Speaker, I now ask for the bill to be read a third time.
The question, members, is that Protection and Prevention Act 2021 be now read a third time. Those in favor? Aye. Those against? The ayes have it.
A bill entitled An Act to Make Provision for the Prevention of Sexual Harassment and for Connected Matters, read a third time. And passed. And passed. What's next? Recommit statement.
Thank you, Madam Speaker. I now ask for statements by ministers.
Yes. Members, may we have the suspension of standing orders to allow us to recommit items that were not done, and we will go back to the item statements by ministers. Statements by ministers.
Yes, thank you, Madam Speaker. Madam Speaker, I'm pleased to provide the House and the public with an update on activities in the youth and children sectors and plans for moving legislation and related matters forward. Madam Speaker, the onset of the coronavirus last year posed many challenges as we had to adjust quickly, pivoting to ensure that the nation's young persons during the period were still engaged and continued to enjoy the benefits of the programs that the Ministry of Education, Youth and Information provided for them, albeit virtually. Madam Speaker, despite the challenges associated with the pandemic, we were able to host a successful staging of Youth Month 2020. Youth Month is celebrated each year in November and is a period during which we affirm and celebrate Jamaican youth, providing a platform for focused attention on the concerns and interests of this most critical demographic. Last year's theme, and aptly so, was Rethink Youth. Resilient through entrepreneurship, training, hope, innovation, networking, and knowledge. Indeed, we had to rethink how we would engage our young people, and as such, most of the activities took place on virtual platforms. However, through the support of our partners, we were able to fully utilize traditional and social media to maximize our reach to the youth. Madam Speaker, planning has begun in earnest for the staging of this year's Youth Month. We will be utilizing a mixed modality, virtual and face-to-face, in line with the COVID-19 protocols. The committees are now being formulated. Youth Month Planning and Advisory Committee and the Selection Committee for the Prime Minister's Youth Awards for Excellence. Additionally, packages for sponsorship for the numerous events are being dispatched to prospective sponsors, and the procurement of the required goods and services have begun. Madam Speaker, the staging of last year's National Youth Parliament was such a success that I'm proud to announce that the Ministry received a record of 1,055 applications with the opening of the call for applications this year. The selection process this year was the most competitive, Madam Speaker. Nevertheless, the new 2021 cohort of young parliamentarians is in place and ready to execute their various community and county projects. Additionally, this year, Madam Speaker, we have a representative sample of young persons from rural and urban Jamaica, and a 50-50 gender balance amongst the 102 youth parliamentarians that just recently had their first meeting with the Honourable Robert Nesta Morgan, giving them their charge to be exemplars to youth across the nation. Madam Speaker, the National Youth Advisory Council of Jamaica has been active in informing government policies throughout the years and has made some contributions in areas such as the National Youth Policy, the NIDS Bill, the National Plan of Action for an Integrated Response to Children and Violence, the Disabilities Act, the Grooming Policy, and the Regional Platform for Disaster Risk Reduction in the Americas and the Caribbean. The National Youth Advisory Council of Jamaica also acts as a steering committee for the National Youth Parliament of Jamaica, guiding the execution of projects and preparing their presentations. After a rigorous application and selection process, 20 national youth advisors were appointed by the ministry in April of this year. In a bid to also ensure a 50-50 gender parity of 10 males and 10 women, 10 men and 10 women, members of the 2021-2023 cohort of the National Youth Advisory Council of Jamaica have already started to gain representation on ministerial boards, for example, Factories Corporation Limited. With regards to the Youth Jam sessions, Youth Jam virtual empowerment sessions premiered in March 2020 as the Youth and Adolescents Policy Division shifted engagements to virtual platforms. The empowerment sessions are executed both through Zoom and via the Instagram Live platforms. They're hosted for 30 minutes and deliver training to our youth with a specific focus on mental health, entrepreneurship, innovation, knowledge, monetizing their brand, and sexual reproductive health. This program is still ongoing, and the flyers are posted weekly on the ministry's social media pages. With regards to the Prime Minister's National Youth Award for Excellence 2021, the nomination process will be opened earlier this year to facilitate greater reach and diversity of applicants across a broader cross-section of our youth demography. This signifies a more intense and robust approach to strengthening the sensitization around the Prime Minister's National Youth Award for Excellence. Additionally, a greater emphasis on the promotion of underrepresented nomination categories such as environmental protection, revision and addition of new nomination categories to allow for more representation and diversity. In the area of the Youth Innovation Centers, there are currently 10 Youth Innovation Centers island-wide and 3 Youth Access Points in St. Thomas, St. Mary, and Trelawney. Madam Speaker, as you know, the centers were closed in March 2020 with the onset of the COVID-19 pandemic as a preventative measure in mitigating the spread of the virus. The offices, however, are open to staff who continue to assist the young people virtually in areas of information dissemination, job readiness support in terms of resume assistance, and basic counseling and guidance. Youth Jam sessions, along with other virtual and face-to-face strategies employed by youth empowerment officers, recorded the engagement of 11,824 youth, 4,005 males, and 7,819 women. Unattached engagement amounted to 1,671. $30 million were allocated in the 2021-22 financial period to effect repairs to the Youth Innovation Centers. The status of 2020-2021 carried forward projects are as follows. 7 Youth Innovation Centers repairs are completed. The estimates are being prepared for works to be conducted in 2021-22. It is anticipated that the Youth Innovation Centers will reopen in line with the reopening of schools. Our National Mentorship Program, Madam Speaker, this year, the Ministry will launch its National Mentorship Program, which will provide our young people with the guidance and support of experts in their desired field. These young persons will be chosen from the grassroots or communities and would have shown good attitudes and will go through a program facilitated by the staff of the ministry and partners that will aid in their character development, technical skills, and requisite soft skills that are needed for their success. It is expected, Madam Speaker, that a cabinet submission will be made to approve this program in the next month. Turning now to children's legislation, beginning with the Child Care and Protection Act. The review of the Child Care and Protection Act is intended to address new and emerging issues and to ensure harmonization with other pieces of legislation concerning children. The process is advanced as a draft cabinet submission has been developed to seek approval for the recommendations that were made in the report in the Joint Select Committee of the Houses of Parliament. With regard specifically to Section 24 of the Child Care and Protection Act, the Ministry has found it necessary to accelerate the pace of the revision of Section 24 of the Child Care and Protection Act by pulling out this section of the Act for advancement, even ahead of the revision of the entire Act. Upon revision, no child not charged with an offense will end up in a penal institution. The use of the terms uncontrollable, beyond control, and out of control will be abolished in describing children with behavioral issues and to be replaced by modern, defined terminology to capture the range of behavior exhibited by children. With regards to the Children Adoption of Act 1958, the review of this Act is on in earnest and will address several legislative gaps and ambiguities and areas in which a law can be updated to reflect the scope and types of adoption applications currently being received. The process has begun as the Ministry is treating this matter as one in need of urgent attention. A policy document has been developed which has informed the crafting of a draft cabinet submission that the Ministry is currently refining to advance to the next stage. Madam Speaker, the Child Protection and Family Services Agency provides care to children declared as in need of care and protection by the courts, and those who are awaiting the outcome of court proceedings in this regard. At the end of March 2021, there was a total of 4,569 children in care. Of that number, 2,999, or 66% of children in care, are living in familial environments, meaning foster care, family reintegration, kingship care, and supervision orders, while a total of 1,570, or 34%, are living in children's homes and places of safety. During the pandemic, the homes continued to follow the necessary protocols which were established to reduce risk to both staff and wards. Each home secured a quarantine area and ensured that new wards who were being placed at the facility were isolated for the required time before being placed with the general population. Whilst a number of homes were affected by COVID-19, thankfully it was not significant and the impact within the sector was minimal. With regards to licensing of children's homes, the Child Care and Protection Act, Children's Home Regulations, make provision for all privately operated children's homes and places of safety to be licensed. Each institution is relicensed every 3 years after going through the reapplication and assessment exercise. The homes are due for relicensing in 2021, and already they have been engaged in the process. It is important to note, Madam Speaker, that the Ministry will not be issuing a license to any home that has not met the standards as required by the regulations. Currently, a total of 34 of 41 homes have been issued with licenses approved by the Honourable Minister of State. One home has already been closed, and we are looking to close another. The other homes must meet the criteria as listed at Section 3 of the Children's Home Regulations to be issued with a license. Madam Speaker, the Maxfield Park Children's Home is a government company which is funded by the government to the tune of $8.5 million per month. The ministry is proposing that the status of the company be changed from being not just fully funded to being a fully managed government entity. The ministry is also proposing the rehabilitation of the Maxfield Park Children's Home into a center of excellence for child care, which would provide both residential and outpatient services. Outpatient services would include counseling, facility for recreation, and time out from school. The facility would also be technologically equipped to provide the best living and learning environment for our children. A task force is being established to guide the renovation of the facility. Turning now to street children, with technical support of Winrock International, the study of children living and working on the street was completed and submitted to Cabinet for approval. An analysis of the root causes underpinning children living and working on the street indicate that consumption poverty is the most obvious push factor for child labor on the streets, and the potential for quick monetary gains is the most significant pull factor. Cabinet's approval was secured for the circulation of the final document, as well as for the establishment of a multi-sectoral body to review and finalize a street and working children framework of action and oversee the implementation of said framework of action. The CPFSA is currently in the process of establishing the task force. Madam Speaker, the Ministry, working with the CPFSA, has developed a policy to accelerate family-type placement of children 3 years and under entering state care. This will ensure that children 0 to 3 years old who have entered state care are placed in an approved placement under a foster care arrangement until their case is resolved either by family reintegration, kingship care, or by some other appropriate permanent placement such as adoption. A draft Cabinet submission has been prepared and is currently circulated to the relevant stakeholders for comments. Upon receipt of these comments, the approval of the Cabinet will be sought for the Ministry to embark on the policy direction. Madam Speaker, the Ministry, through the CPFSA, will be embarking on a positive or good parenting campaign in an effort to empower Jamaican parents to raise happy, healthy, and smart children. The Ministry will also be embarking on a corporal punishment campaign where parents will be encouraged to try positive discipline strategies. Both campaigns will run for a total of 4 years in separate phases. The Ministry is preparing to go to tender to engage a public relations company to lead this activity. Finally, Madam Speaker, as a part of our reforms to the child protection ecosystem, we have received approval from the Office of Utilities Regulation to activate 211 as a singular helpline for children at risk or for anyone who wishes to report child abuse. Madam Speaker, we will be launching the 211 helpline on the 6th of September. This helpline will be manned 24 hours by child care professionals and will be a significant addition to the child protection ecosystem. We will be running a national campaign to inform Jamaicans of this new helpline, as we will transition it to be the main helpline for reporting child abuse in Jamaica. And because it will be easy to remember, we know that it will be used in those times. Madam Speaker, I cannot end without acknowledging the work of our State Minister, the Honourable Robert Nestor Morgan. He's been leading the review of the Adoption Act, the CCPA, and amendments to Section 24, as well as the policy for accelerating family placement of children 0 to 3 years old, and is pushing the implementation of the 211 hotline. I've also charged him to continue his focus on the youth portfolio, with particular concentration on improving the work of the Youth Innovation Centres, as well as a general review of the work of the Youth Division. He also meets with all his divisions within his remit every Monday to get updates related to children, youth, and information. Minister Morgan, your support and determination do not go unnoticed. I thank you. Thank you, Madam Speaker. Yes.
Minister, just two questions. You spoke about closing children's homes, and I understand if they're not meeting the requirements, but does that solve the problem of where you would place these kids once you have closed them? And wouldn't it be better to try and bring them up to the standard and work with them so that they can meet your own requirements? Because I know that we don't have enough spaces for all the children that need to be in homes. So that's the first question. And secondly, in relation to youth, there are a lot of activities that you have identified which are all good, which no one could question or argue with. But we have a large number of what we might call unattached or at-risk young people. And I wanted to find out what the ministry is doing in relation to reaching out to them. Many of them have fallen through the cracks due to COVID in the education system, and they need particular attention. As speaking to principals, they have just dropped out of the school system, and I don't know if there's anything in place to track them, to determine whether what they're doing, and to seek some intervention for them. Before you answer, could you also, as just looking at the figures from Maxfield Park, how many children are actually housed at Maxfield Park? I was just looking at the monthly recurrent budget, which seems large, 8.5 million, but I don't know the context of staff and how many children are actually served there.
Thank you. Thank you, Member. I'll start with the Maxfield Park Children's Home. There are 79 children there. And 102 caregivers. So actually, there's a good ratio. Right. With regards to your question about closing of homes, why not work with them? We do, but we've found over this period that a larger home is more efficient to run, to manage. A home with more children is more efficient. Right? Some of these homes have 8 and 6 children, and so we would definitely help to transition. We'd help to transition those children to other homes or to families, and as we deinstitutionalize, right? Yeah. And with regards to your question regarding unattached children at risk. As you know, we recently announced a national summer program, and particularly focused on those children that we have not seen to have been engaged consistently with the education sector. School leaders, school staff, parents, plus all the information that we've been sending out. We are getting reports that at the various schools, the children are coming, the parents are showing up with them, and we've been able to make contact with many that we were not able to before. I know there's still a lot of work to be done to ensure that we find all of those children who are not engaged with the education system, and we will continue to do that during the summer, and into the next school year to ensure that we account for all our children in the system. Thank you.
Announcements.
Laid on the table of the House today are the following: the Bauxite Production Levy Act, Capital Development Fund, withdrawal number 1, Order 2021, and the Certified Appropriation Account for Head 8,000, Independent Commission of Investigations for the year 2018-2019.
Bills brought from the Senate, petitions, papers, reports from committees, notices of motions given orally, and we did questions and answers to questions already. So we are now at motions that may be made at the commencement of public business requiring notice, motions relating to sittings of the House, motions for leave to introduce bills, presentation of bills without leave of the House first obtained, and members, we're now back to public business. Minister Chuck, thank you.
Madam Speaker, it is my intention at this time to close the debate on the two bills, number 1 and 2, on the order paper. Hello. Sir, circulate them for me. I'm closing. You want to speak? If you want to speak, I'll... Sorry, Madam Speaker, the member from Southeast Clarendon would like to... Southwest, before I close. Go ahead.
Is the appellate jurisdiction? Madam Speaker, I wish to contribute to the debate in respect of the amendment to the Act to amend the Judicial Appellate Jurisdiction Act, which the debate is ongoing. Madam Speaker, it is no secret that I am not in support of this bill. In fact, to put it into simple terms, this bill represents a situation where the state arrests a citizen, charges a citizen, prosecutes a citizen, acquits a citizen, then turn around and say that, oh, we made a mistake and we need a second bite at the cherry. And that, Madam Speaker, is very oppressive. In fact, what it does is that it erodes confidence in the certainty of judicial decisions. It's a very important principle, Madam Speaker. And so, when you look at it, and you take all of the circumstances into account, us as a parliament and the executive must tread very lightly when we are trying to interfere with judicial decisions. Madam Speaker, we have to. When you look at the circumstances, Madam Speaker, most of the persons who we represent in here are from a class that is not able to pay for them legal fees. And when you look at the resources available to the state as opposed to the resources available to the common man, Madam Speaker, it is very unfortunate that we are going down this road. It appears as if the common man doesn't stand a chance in this system. And that is how it appears. What we are engaging in
is we are looking at a bill that may lead to a perpetual continuing, a perpetual continuation of litigation. Take this into account. We have a situation now where it takes us several years between the moment a person is charged to the moment a person is either acquitted or convicted. There's nothing in the proposed bill which seeks to place a limitation on how we approach this particular decision. There's no timeline. There's no statutory limitation. So where I hear the minister saying that, oh, other jurisdictions have it. But what those jurisdictions have that we don't have is an efficient justice system. We do not have an efficient justice system. So this bill is like putting the cart before the horse. Before we can get to this stage, we need to ensure that the justice system we have now is working, that we clear the backlog that is there in the systems. There's a lot of backlog of cases. Just today, Madam Speaker, a trial was supposed to proceed, a trial of national importance, and I am told that the trial has been postponed to next year. That's just a simple example of the circumstances and of our realities. Our realities now does not afford us to have a bill like this. We have to take into account, for example, and the minister knows very well, the culture of the Office of the Director of Public Prosecutions. We have to take into account the fact that 90% of the persons who serve on the bench as judges have come through the Office of the Director of Public Prosecutions. And that's undeniable. Madam Speaker, I believe that the proper approach to be taken with this bill is for this bill to be referred to a joint select committee of Parliament so we can do a thorough analysis. We need to ensure that we place our priorities in the right places. This is a misplaced priority in terms of the justice system. We do not need this bill now. What is the mischief that this bill is designed to cure? What is the mischief? There's no mischief. Them say that if it is not broken, don't try and fix it. And that's exactly what we're doing now. I hear the minister speaking about the right of the victim. Of course the victims have right. We all agree to that. But the accused person has a right too. And the burden of proof is placed on the prosecution. He who alleges must prove.
That's an axiom of law.
So if, for example, you're going to talk about the fact that the accused will have the option to seek legal aid representation if he cannot afford the second trial. That's unfair. It's unfair because we, at the defense bar, we struggle to collect legal fees. Oftentimes we proceed to trial without even being completely paid. Now this person is going to be told that you have to go to legal aid. The matter goes to the appellate court. Who is going to represent him when that appeal is being made by the Director of Public Prosecutions? Who is going to represent him to ensure that the system is fair, that there is balance? We have to be careful how we approach a bill of this nature. It's a long-established principle of utter for acquit, utter for convict. It's what the Americans call double jeopardy. It means that if somebody is charged and you bring that person to court and a decision is made, that should be final. Why are we going to go back down the road? When are we going to stop? When is the DPP going to stop? Another issue, Madam Speaker, that we have to consider. When this matter goes to the Court of Appeal and the Court of Appeal rules either on a point of law or a point of fact, and then there's a retrial, what do you think going to happen when the jury sit down and hear that this man was acquitted but the Court of Appeal sent back the matter for retrial? It's almost a sure conviction. So the person is not afforded a fair opportunity to defend himself. We have to look at the thing holistically. The way we're looking at it now is not fair, it's not balanced. And our economic realities and the hardship we face now does not lend itself to the effective implementation of a bill of this nature. So, when you look at it, you're going to give, this bill proposes to give, right, the DPP the right to appeal against no case submissions. It's a point of law. The bill proposes to give the judge the power to deny bail to a person who has been acquitted. That is what this bill is proposing. So if somebody is acquitted, the judge can say, well, you have to stay in custody until this matter is resolved. That is unfair. Once that judge or the tribunal determines that the person is acquitted or is free to go, the matter is at an end. So this bill is very oppressive. It is skewed against the common man out there. The person with all the wealth of resources, he can afford to be engaged in continuing litigation. The poor man cannot. The poor man wants a chance to get acquitted so he can go to the embassy and get a visa and leave the country and find an opportunity elsewhere. If 20 years you have him engaged in litigation, how am I going to get an opportunity to help his family and help his children? It is oppressive, Madam Speaker. You know, I'll tell you. When you look at, for example, the amount of money that is available to the Ministry of Justice, the Crown, it's $9 billion them have, you know, as a budget, you know. $9 billion they have to ensure that they get it right. You're going to give them an opportunity to correct a mistake, to make another mistake. It doesn't make any sense. And I don't see the purpose for us rushing a bill like this through the Parliament. A bill of this nature, the proposals therein are so significant that we need to have a broad consensus, a broad analysis, a broad discussion with all areas of society regarding this particular change. The Constitution affords a person the right against utter for acquit convict. However, I will concede that what is required here is a simple majority to pass the bill through the House, and that is my biggest concern. Because such an important right can be taken away by virtue of a simple majority without a broad consensus, a discussion in Jamaica about it. I don't want, Madam Speaker, we need to be careful. We need to be careful how we approach legislations like this. We need to understand that even though it exists elsewhere in the Caribbean, we have to look at our realities before we force through bills of this nature. It should be sent to a joint select committee of Parliament. That is my humble opinion. The prosecution, Madam Speaker, already has the power of null prosecute. And that power affords the prosecution to discontinue a matter at any stage during the proceedings if they realize that something during the proceedings, if they are of the view that it is, if they want to correct something, if they want to amend something, they have that right. It's a blanket right they have. The defense cannot challenge it. It is their decision to make. They already have that right. And so I don't see the purpose of further depriving the Jamaican citizens of a right to the benefit of the government. Because all we're doing is that we're taking away the right of the citizen and further strengthening an arm of the state to continue to use this as a weapon against the citizens. I repeat again, that's oppressive. And I know with the greatest of respect, the minister has the best of intentions. And he's hoping that if and when this bill passes through the House, that the DPP or the office of the DPP will be sparing in terms of the use. But there's nothing to determine that. They can appeal almost every single acquittal. And 90% of the time, I can speak from personal experience, when a judge makes a decision, they don't accept it. They don't accept the decision of the judge. Sometimes them vex and them cuss. And we all experience it at the bar, we know. So that is why we have to be careful who we give the power, which organization, and the culture of the organization. What is the need for judges? If we are giving the DPP the right to appeal and no case submission, what is the purpose of a judge? I don't hear anything coming from the minister in respect of what they are proposing to do with the justice system. Nothing about increasing courtrooms or spaces available for trials to proceed. Nothing about judiciary, increasing the number of judges we have. Nothing about strengthening and increasing the number of prosecutors we have to deal with the matters. So the country is just not ready for something like this. We have to sort out those issues, those clinks, before we can come with a bill like this and ask us as parliamentarians to seriously consider it. We are here to represent the masses of the people. Not an organization or an entity of the state. The masses of the people who voted and put us here to represent them.
That's a responsibility of all of us.
And we cannot sit idly by and allow a bill to pass through this house that is going to be so oppressive, that is going to deprive the citizen of a right in favor of the crown, and have our young men and women who sometimes are, well, every single man or woman who is charged is innocent until proven otherwise. But that part about proven otherwise, is going to be the important part, because that means that he can take forever to prove himself innocent if we allow this bill to go through. Because if the prosecution is not comfortable with the decision of the court, then they can decide to keep the person in litigation for the rest of his natural life.
Unfair. One justice.
We are now at a point in this country where we're getting trial dates for 5 years down the line. Certainty of trial dates now, we're coming with that. 5 years, we have dates for 2024, 2025. Where do we stop? Where do we stop?
That's it.
We have to stop somewhere. And the buck stops with this parliament. And I'm asking all well-thinking members of parliament here to look at the bill, look at what it is proposing, seriously give some consideration to it, and vote in the best interest of the Jamaican people. This is not about PNP or JLP. I don't talk about that now. I speak from experience in the justice system, and I can tell you that this bill that is being proposed, and I said, don't know why you're rushing to finish it today. No, with all due respect, the minister knows I have abundance of respect for him. We are colleagues at the bar. We are colleagues at the bar, and I have a lot of respect for him.
No,
right?
Not the one downstairs. Not the one downstairs.
Speak about the justice system, not bar. It can be misinterpreted.
You know? And Madam Speaker, in closing, I just want to urge the minister and the government in general to look at boosting the police investigatory resources. That is what we need to look at. The witness protection program is also important. We need to look at that. Yes. Trial efficiency, important. Without trial efficiency, Minister, this bill you're proposing is a waste of time. Without trial efficiency, it is a waste of time and will be a waste of government resources.
Justice to the people.
Because the DPP would be continuously getting resources to re-prosecute and re-prosecute and a recurring decimal. How is that something that is acceptable in a modern and democratic society? It can't be acceptable. And so, I stand here, Madam Speaker, in solidarity with the people of Jamaica, but all counsel at the criminal defense bar in saying that this bill needs some more proper and thorough ventilation and analysis before we decide to go forward with it. And I'm urging, Madam Speaker, that the Minister take my recommendations into account and refer this bill to a joint select committee of the House of Parliament so that we can look more closely at the provisions that are being proposed. I thank you, Madam Speaker.
Madam Speaker, I certainly would like to thank the contributors, in particular the member from St. Andrew South, and also the member from Clarendon South West, and also the Bar Association, with whom many members, I had a virtual meeting with them on the 10th of June, and also they submitted a 24-page documenting their position on the bill. I normally do not spend an extended amount of time, Madam Speaker, to respond in closing debate. But because of the extensive presentation made by the Leader of the Opposition, I intend to go through in somewhat detail some of the points he made, in support of the bill, by the way, but with some modification he proposed. And having listened to the member from Southwest Clarendon, like his passion and his contribution, but as I will show shortly, they're mainly misconceived, ill-conceived. And I will, with due respect, I will show you why they're ill-conceived. There's no doubt, Madam Speaker, that this particular piece of legislation has been long in coming. Started out from 2014 with cabinet submissions from the last administration, two pieces of legislation, submissions which I've read extensively, came before me in April 2016 as a defense lawyer. From I hear double jeopardy, I don't like it. So as a defense lawyer, I certainly let me have a look carefully. And then, Madam Speaker, over the last few years, we have gone through to refine, and we have refined, and even this bill that is now before us is further refined to make sure that we have it right, which I will speak to in a moment. But, Madam Speaker, double jeopardy, autrefois acquit, as it said in our common law, is one which is well ingrained in the common law. Came to the English common law in the 12th century from the Roman law. And therefore, what we're looking at is to interfere with 800 years of experience against double jeopardy or autrefois acquit. Over 800 years. And in truth, Madam Speaker, it is only in the last 30 years or so that legislatures across the Commonwealth have decided to interfere with this particular common law principle. But, Madam Speaker, with due respect, it is justifiable. And the reason why it is justifiable, Madam Speaker, judges do get it wrong. Judges do make errors. And because judges make errors, as a defense attorney, I was very successful in appealing for accused because judges make errors. And when they make errors, Madam Speaker, on points of law, which is oftentimes the case, I was successful. But, Madam Speaker, at the end of the day, the accused may have been acquitted in the Court of Appeal, having been convicted in the lower courts. But what about the victims, Madam Speaker? When at the Supreme Court level, the trial level, judges make error and the accused is acquitted, how do the victims feel? Because the rights of the victims are affected and not protected. And, Madam Speaker, if the victims feel that they can't get justice in the courts, you know, Madam Speaker, they will take it out on the street. And all that one is asking, Madam Speaker, there must be balance and fairness in the courts. And there's no doubt if the case was properly tried, no errors, and the accused was acquitted, then so be it. But, Madam Speaker, where the judge has made an error, it can be right if there's a conviction, the accused has a right of appeal. But if there's an acquittal, the victim, with no one arguing for him, must take it as it is. Can't be right. And, Madam Speaker, regrettably, in the last 30 or 50 years, trials are being corrupted. Fraud has been imposed, and in many cases, justice has been perverted because accused persons have big money and can buy out witnesses and buy out jurors and buy out everyone. And the end result, Madam Speaker, is that the victim know that they have been victimized once again while they depend and expect the state to give them justice, and they don't get justice. So, Madam Speaker, the Commonwealth, courts and legislatures across the Commonwealth, including the Caribbean, appreciate that these are matters which have to be addressed, because if they're not addressed, we're going to get the retaliation and the reprisal out in the streets. And I dare say, Madam Speaker, this is what I believe is happening too often, because victims of offenders feel that they're not getting the justice in the courts. So, Madam Speaker, even though I respect the Archifoist acquit doctrine, double jeopardy doctrine, I know, and I, as a defense attorney, I share, Madam Speaker, I share, member from Southwest, the passion and the understanding. I explained that to the defense attorneys, but as Minister of Justice, I have to balance between the victims and the accused. And that is why, Madam Speaker, I'm asking this Parliament to approve the legislation which I'm about to explain. Madam Speaker, having heard from the Leader of the Opposition, having heard from the Bar, we have corrected the bill significantly, so that there will be only 4 occasions on which there can be an appeal from the prosecution. On the point of law, where there's an error of law. Secondly, where there's an administration of justice offense, that is, there has been a perversion of justice. Thirdly, where the sentence is too lenient or against the law. And by the way, those 3 are strongly supported by the Bar. Right? And the president of the Bar and radio support those 3. And the 4th, Madam Speaker, is where there's new and compelling evidence that in the public interest, or in the interest of justice, should also have a retrial, which was the case that gave England the impetus to to provide new legislation giving the prosecution a right of appeal because of new and compelling evidence in the case of Stephen Lawrence in the 90s. And because of that, Madam Speaker, England enacted the right of appeal in 2003. Having said that, Madam Speaker, let me respond firstly to the Leader of the Opposition, and in doing so I may not go in detail, but as I go through the bar and through the member from South West London, I will cover everything. Madam Speaker, in his presentation, the Leader of the Opposition supported this right of appeal by the prosecution, though he had some correction. Indeed, he says, the Leader of the Opposition, based on the right against an inappropriate sentence, the right of appeal is justified. Fine? And I accept that. So that where a sentence is inadequate, too lenient, or against the law, there's no doubt it needs to be corrected in the Court of Appeal. The Leader of the Opposition mentioned that the DPP should give his consent to the appeal in the case of the private citizen, but not in relation to agencies like FID and MOCA. To be fair, Leader of the Opposition, the DPP must act in the public interest. So whether or not there's a right of appeal, he or she must consider the public interest, and therefore in giving the consent, the public interest must be paramount in deciding whether or not an appeal should go forward. Then the Leader of the Opposition mentioned that when he submitted to a cabinet, the basis on which he saw the right of appeal was that there should have been a substantial miscarriage of justice. And nowhere in these two bills does he see this. My friend, I disagree totally. Because if you say that the appeal should be based on a substantial miscarriage of justice, it means that if it succeeds, Madam Speaker, it is almost telling the judge or the jury in the retrial, you should convict. Because if you only if you only succeed on a substantial miscarriage of justice, you would have to demonstrate for the Court of Appeal to allow the appeal that at trial there should have been a conviction. And therefore, when we send it back, we expect you to convict. So, Leader of the Opposition, that is why we say, and we will agree, that in the Court of Appeal, in considering whether to grant an appeal, the application and the appeal, we say in the interest of justice, because the retrial should be able, because it has been impeached because of the error of law or administration of justice, that those impeach the trial. So when it goes back, it should be a fair balance. It can go either way, acquittal or conviction. So the Court of Appeal must not be persuaded on the substantial miscarriage of justice, but on the interest of justice. So we accept the interest of justice point you've made instead of the public interest. And, Madam Speaker, the Leader of the Opposition also mentioned that he would have used the term obstruction of justice instead of administration of justice. But as you can see, Leader of the Opposition, the administration of justice offenses, perjury, interfering with witness, and so on, they look more like administration of justice rather than obstruction of justice. So we are going to retain the phrase administration of justice instead of obstruction of justice. And we agree with you, and the proposal is being put forward in the amendments to change the public interest to interests of justice, as I pointed out to you recently. Madam Speaker, the Bar Association made a number of points, which you also made, Leader of the Opposition, that there should be no appeal based on facts, and we accept that. So in the amendments, we are going to delete any appeal based on the jury or a judge getting it wrong based on facts. So that has been removed. But we will still send it for reference, not a retrial, but reference based on mixed law and facts. So there are some cases where the appeal of the prosecution is not to ask for a retrial, but to ask for a reference based on not only error of law, but also mixed law and facts. Just for the purpose, really, that it may be a case of some significance where a real significant error was made and the Court of Appeal need to give some direction to the lower courts. Okay? So that, I think, would be useful. So the matter is finished. Now, the next point, and this member from Southwest, Clarendon, clearly are not in touch with the Bar Association. With due respect, we did, when we did indicate to them that, yes, we are going to remove the issue of facts. But I think you're right, and the Bar is correct, that if a man is acquitted, then there is no charge against them. So the issue of him getting bail doesn't arise. So that will be removed. Okay? So that will be removed. And, member, bear in mind that we are saying that, however, if the DPP should succeed in the appeal, then a charge can be laid, and that's the only time that bail should arise. Because when he's acquitted by the lower courts, there's no charge, so there's no question of bail doesn't arise, and that was wrong in putting it in the bill, so we're removing that, okay? The next question is the question which you have posed, and a very important point, that cases now are coming to appeal and taking too lengthy periods of time. It is something which I've complained about. It is something I'm concerned about, and it is something that we have to address. So, member from Southwest London, listen carefully, because I'm trying to show you, I'm dealing with your point, and to show you that some are impulsive, but some I'm accepting. No, you're correct that it is taking too long for cases not only to be tried, but worse, if there's a conviction, for there to be appeal. This bill, when it is passed, and you will see it in the amendment, the prosecution, if they have a right if they apply for an appeal, if the case cannot be tried within 18 months, that's the end of the matter. You get me? So in other words, if the transcript and the appeal is not allowed, and the case is not tried based on an error of law, administration of justice offense, or even the sentence, if the transcript, etc., doesn't get to the Court of Appeal, and the appeal is dealt with within 18 months, it can't. That's the end of the matter. Right? So what we are saying is that even though it will be law, if we don't expedite the flow of the transcript to the Court of Appeal so that matters can be dealt with within 18 months, then the right of appeal will not go forward. And you're right, member from Southwest Clarendon. We have to do more to expedite cases in the courts. But you're wrong in that we have not done enough. We have doubled the number of Court of Appeal judges. We have spent just under 900 million to give them the first-class facilities. And it's obvious to me you have not been there, because if you had been there, you would never have said what you said. And I urge you this week to visit the Court of Appeal and see the outstanding facilities they have. It is one of which not only am I proud, all Jamaica should be proud of. And very shortly, we are going to, the DPP office will be open in a similar first-class facility. I'll make sure you visit. And you talk about doubling the number of judges. In our time, we have moved the number of judges from 26 to 42. We have moved the parish courts from about 50 to 70. We have moved the number of prosecutors from about 48 to 60 odd. And what is more, clearly you're not visiting the Supreme Court. We have increased the number of trial courts to 12. And you come from Taranan, and you have not been to Chapperton Court? First-class facility at Chapperton Court? And Maypen will be fixed up before the end of the year. So when you talk about providing nothing to show improvement in the court system, please, with due respect, a lot is happening, because before I leave this place, and I want to leave soon, we want to have a first-class justice system. No, Madam Speaker, the truth of the matter is, we have listened to the bar. I've examined the bar very carefully. We agreed to the point and facts. And as I say to you, I can show you that everything the bar has said, we have accepted, because if you notice, even not while you were speaking, I tick where they have agreed and showed, and I said everything that basically they have indicated that would improve the bill. As the leader of the opposition and yourself, we have tried to improve the bill so that we have a bill which is really at the very minimum that one could ask. The only thing the Joint Select Committee could do is to expand it more, and that is what you don't want. So we have minimized it to errors of law, administration of justice offense, and appeal against sentence. The fourth matter, Madam Speaker, I have to emphasize that it came, my good friend from Southeast St. Andrew sent me a lecture from a very outstanding judge, Patrick Robinson, judge of the International Court of Justice. And in this presentation from Justice Patrick Robinson, he begged, literally begged, Jamaica to put in place the right of appeal, and indicated that this particular section, new and compelling evidence, substantiated by the interest of justice, should also be a part of the right of appeal, which was a part of the UK legislation, which is the fourth limb of the four areas on which an application can be made. And you know, Madam Speaker, and I will quote it, because the member at another bar not far from here keep repeating it to me. The member, the Justice Patrick Robinson, said he thinks that snow may come to Jamaica before this bill is passed in the House. And the reason, Madam Speaker, he said that, because he feels that the defense bar has too much strength and persuasiveness that they can't convince Parliament. But I'm here to ask parliamentarians, when reason succeeds, we must succeed in passing this bill. And not only that, it is quite clear that the opposition from the 2014 wanted the right of appeal. And what we have done, Madam Speaker, in the last 3-4 months as I debated, not only with a member from Southwest Clarendon at another bar, but also with the Bar Association, we have narrowed it to the very minimum that you should be very happy with. And now that you hear what I've said to you, member from Southwest Clarendon, I expect you to support the bill. Because even you talk about the timeline, we have given you 18 months, if it must be done within 18 months. And the whole question, member, about continuous trying, no, once. And after that, done. So this question about continuous wouldn't arise. And when it comes to the legal aid fees, interestingly, member, only yesterday, I took to Cabinet an improvement to the legal aid fees, which was approved, and things will be a little better. Right? Much better in terms of what attorneys will be paid to do legal aid. Because we're considerate of the justice that must emanate in this country. Because without justice, there can be no peace. And therefore, justice has to be balanced. Justice has to be both sides. Because if the victim doesn't get justice, there will be no peace. And that is why, Madam Speaker, the passage of this bill will send the right signal to those who would want to corrupt the trial process, that if you do so, an appeal could shift and ensure that another appropriate trial takes place. So all I'm saying is, yes, one member of the bar, to be exact, QC Peter Champagny, is a bit concerned that with this bill, you're not going to have too many rights of appeal. That's okay. But in appropriate cases, we will. What he says is that there's a right of appeal for bail. And it's only and it has been there since 2010. And the prosecution has only used this right of appeal for bail only once since 2010. The truth, Madam Speaker, is that in most Commonwealth countries, this right of appeal, even though it is present on most of the legislatures in the Commonwealth, it's unlikely they get more than one appeal, an average every 3 or 5 years. But it sends the right signal, Madam Speaker, that it is there, and if you corrupt the system, or if you put in a lenient sentence, or if you have an error of law, at least justice can be corrected. Madam Speaker, sentence has been a real problem, and people complain about it. Here now, Madam Speaker, there's no doubt in my mind that at the trial level, more should be done, especially impact statement, victim impact statement, so the concerns, the feelings, the passions of the victim should be taken into consideration when sentence is imposed. And I say, Madam Speaker, if at the trial level the prosecution is heard, and the prosecution can take into consideration the concerns of the victims or the families of the victims, then at the end of the day, Madam Speaker, you can have a situation when an appropriate sentence will be imposed. And so appeals against sentence, to my mind, should be minimized or non-existent. Because if the sentence is taken into consideration, both sides, and an appropriate sentence is imposed, there's no need for an appeal. So, Madam Speaker, member from Southwest Clarendon, member from South St. Andrew, your input were valuable. And because of what you have said and contributed, you can see that we have taken it into consideration. We have minimized the number of bases, the bases on which appeals can be done. To send it to a joint select committee would only increase it maybe from 4 to 6 or 4 to 7. So I urge that we accept and give full support to the bill. So, Madam Speaker, I ask that the bill be now read a second time.
Members, the question is... Members, the question is that the bills be now read a second time. Both bills. Those in favor? Those against? The ayes have it.
Madam Speaker, could we take the appellate jurisdiction first?
The clerk has not read the bill.
Sorry.
A bill entitled An Act to Amend the Judicature Applicate Jurisdiction Act, read a second time, and a bill entitled An Act to Amend the Judicature Parish Courts Act, read a second time.
The House will now resolve itself into a committee of the whole House to consider the bill clause by clause.
Madam Speaker, I circulated a number of amendments to clause 2, 5, and 6. Leader of the Opposition, I had circulated them last week to you, and I ask if there are no objections to them, we can go through, Madam Speaker. So if you put the clauses, we could proceed.
Madam Chair.
Yes.
With your permission, Minister, the provision, I don't have the copy of the bill before me, that refers to the completion of the trial within 18 months.
Right.
Right. I want to propose for your consideration that 18 months be amended to 6 months.
No. Not possible. In fact, I must tell you, member, that I had tried to convince my team 12 months, and they said, no, 12 is short. So I agreed to 18 months. Because bear in mind, member, from the appeal takes place, the transcript has to be provided, and then a date has to be set in the Court of Appeal.
Minister, I hear you and I understand that. But remember, the overriding issue from where I am is the long duration for the completion. We should not allow administrative inefficiency, such as the transcript that you refer, to cause the period to be extended. So in much the same way that you compromise with your staff, I will invite you to compromise with us, and I will go for the 12 months.
No, but let me just say this, member. Your good friend beside you from Southwest Clarendon, no, at the moment, you're lucky if you get it in 3 or 4 years. So that is why I said 18 months. But, you know, I don't have a problem with 12 months because that was what I was proposed. But
Let us go for the 12 months, and if later on we need to amend it further on, we do it. But go on the side of...
What I would beg you, member, let us keep to the 18 months, but obviously the Court of Appeal, and because there's no doubt maybe in 5 years' time we should reduce it to 12 months. But at the moment, member, we're going through overcoming a lot of inefficiency in the system. So maybe in 5 years' time it can be reduced to 12 months. So, but I beg you to let it remain at 18 months, okay? Okay, Madam Speaker. Madam Chairman, please proceed.
Which bill are we looking at first?
We do the appellate one first, Madam Speaker. So if you put clause 1 and then clause 2, we will change.
Just a minute with the amendment. Just a minute, Minister. Which one first? Judicial. Appellate. Members,
one second. If you look at page 2, yes, 6B in the amendment. You have it? In the amendment to the appellate jurisdiction. 6B. You see it? So we're saying from the acquittal of the accused, and you want to do a retrial, it must be done within 18 months from the acquittal.
But Minister, I believe the 12 months, you were correct from the initial stage. I don't think you should compromise on your position, your belief. I think the 12 months is what is reasonable.
With your colleagues in the
man, I believe you are correct from day one.
Yes. And we support it.
I support it. 12 months.
I don't have a problem, you know. Okay. All right, so we can change it. Okay, Madam Speaker.
So, Minister, you will guide us as we go through with the amendments.
If you put clause 1 first, Madam Speaker.
Yes. Members, I now put clause 1. Those in favor?
Aye.
Those against? I now put clause 2.
No, Madam Speaker, the amendment was put, but in the amendment itself, at clause 4(6), clause 4 subclause 6b, we had there has not been a lapse of time greater than 18 months. I will accept the position of the members and put 12 months from the date of the decision, which means it has to be expedited. Fine. And Madam Speaker, the amendments have been provided, and so I ask that the amendment with that minor adjustment at 6b, that we substitute what is in clause 2 to the bill. So if we put the amendment to clause 2, Madam Speaker, which has been circulated.
Everybody is clear on the amendment? Members, I now put clause 2 with the amendments. Those in favor? Those against? The ayes have it.
You can put 3 and 4, Madam Speaker.
Members, I now put clauses 3 and 4 with the amendments.
No, just 3 and 4, Madam Speaker. Clause 3 and 4 of the
I
bill.
now put clause 3 and 4. Those in favor?
Aye.
Those against it? I now put clause 5.
No, clause 5, Madam Speaker, have some amendments, so we ask for the amendments to be put.
I now put clause 5 with the amendments as circulated. Those in favor?
Aye.
Those against? The ayes have it. I now put clause 6.
And one change also, Madam Speaker, to clause 6, we put the public interest in, we put interest of justice instead of the public interest, as noted by the leader of the opposition. So
Put clause 6 with the amendment to instead of putting public interest, to use the words interest of justice. Those in favor?
Aye.
Those against? The ayes have it. I now put the title and enacting clause. Those in favor?
Aye.
Those against? The ayes have it.
Madam Speaker, could we go to the next act, the Parish Court?
The Judicial Parish Courts Amendment Act 2021.
Leader of the opposition, the one I gave you last week had juror in it. But obviously in the parish courts you don't have jurors, so the new amendment doesn't have it because we picked it up during the course of the week. So Madam Speaker, if you put clause 1 first and then...
Members, I now put clause 1. Those in favor? Those
Aye.
Against? The ayes have it. I now put clause 2.
And consistent with what we did, Madam Speaker, in the appellate, we are going to remove 18 and put 12 in subclause 6. And leader of the opposition, we also noted the problems with the parish court bill, and we have done the adjustment, as you can see in the clause 2. Okay? Right. So we can put clause 2 as amended, Madam Speaker.
Members, we now put...
Yes, Madam Speaker, Madam Chairman, rather, Chairperson. Just to be clear, the 12-month period is the period within which leave to appeal must be sought.
No. The appeal must be dealt with in 21 days. The DPP must apply within 21 days. And then the appeal must be heard, and the appeal must be heard, and a new trial ordered within 12 months.
Well, I mean, I'm just looking at 6, subclause 6 of the Supreme Court bill, which is, I assume, similar, and it says, the court may grant an application for leave to appeal if the court is satisfied that there has not been a lapse of time greater than 12 months now from the date the decision that is the subject of the appeal.
Yes.
So it seems to me that that is suggesting that what the 12 months is applying to is when you're applying for leave, the grant of leave.
No.
You can only grant leave if not more than 12 months has passed since the conviction
That is
or the
correct.
acquittal.
That is correct.
Yeah.
But is
the
that
actual
clear?
hearing of the appeal,
it's not
the
clear,
actual
Minister.
hearing of the appeal could be much further out, depending on available court
No, the
time.
trial may, no, but the appeal must be, the application and the leave must be heard and decided within 12 months. I had said 18 months, but within 12 months.
That is leave to appeal.
No, no.
That's what it says, Minister, leave to appeal. It doesn't say that the appeal would be heard. It says
But
leave to
Madam Speaker, the truth of the matter is that leave to appeal is usually almost simultaneous with the leave.
You know, member, the one thing though, when we pass the acts in here as legislatures, we have to be careful because after the act is passed, we have to be careful that this is indeed what the legislature, what we as legislators intend to pass.
Right.
Because in looking at some acts that we have passed, I am sure that as legislators we didn't intend. So I really would like, I think it's important, because what we have here says leave to appeal, and it doesn't matter that we think that it would happen almost together. It can be otherwise, and the law is saying leave to appeal. It doesn't say that the trial, which means that the person could be tried long after 12 months have passed.
I agree, Chairman. This needs to be clarified, I believe. You're correct. When this bill passes through the House and becomes an act, we always have the issue as to what was the intention of Parliament. We don't need to have that now.
There are several acts that are before that we have passed. And when you look back at it, it could never be the intention of us as legislators. So I really think we have to be careful with the wording.
You don't want it to be vague, and it has to go to the Court of Appeal to be resolved.
The position, you see, Madam Speaker, my understanding is that when leave is granted, usually when you put in a notice of appeal and it goes before, leave is not granted until not only is the transcript ready, but usually it goes to the Court of Appeal, leave is granted, and the appeal is heard always, is always simultaneously.
The important word that you just used, Minister, is usually. And we want to be sure as legislators that what we are saying is that leave to appeal and the person ought to be tried within the 12 months.
Well, I mean, it's a simple fix, you know. Instead of saying the court may grant an application for leave to appeal,
you would like
it just say the court may allow an appeal.
Well, why don't we do that?
Yeah.
We can, but I think it's important that
would apply to both subclause 6 in the amendment sheet for the appellate.
So we would, Madam Speaker.
Drowning in paper here. Yes.
We could just add. No, not just grant an application for leave to appeal under subsection 282 if the court is set for leave to appeal under subsection 2 and 2 and grant and allow the appeal. So in other words, the court may grant an application for leave to appeal under subsection 282 and allow the appeal.
Maybe we could ask the draft person who is here, please, because I think it's important.
It's very important, Chairman.
I suggest you don't rush this. I know you want to do it today, sir, but I don't think you want to make a grave error that will make the whole thing problematic. The point, as I understand it, what you have accepted is that there should be a 12-month time frame within which the appeal must be complete. Yeah. And so it needs to be drafted accordingly.
I do agree with that. We should.
Policy shift, and it should be reflected in legislation. Properly reflected.
Madam Chairman, the drafts, CPC has given a good leader of the opposition. At the end of where you have at the end of the subclause 6, and the court may, she's suggesting if you remove may at the end. No, both. We will change it in the next one. But in this parish court one, at the last 2 lines on the subsection 6, and the court may, in any case where such leave is granted. She says if we remove may, and the court, in any case where such leave is granted, proceed to hear the matter accordingly, which is the point I was making earlier. So you remove me, Madam Speaker, Madam Chairman, and say once leave is granted, the appeal must be heard.
But but it doesn't say how quickly.
It's still right away.
That doesn't solve it, because the question is really all that is required to have been done within the 12 months is a granting of leave. Not the hearing of the appeal.
No, but when you remove may and the court, in any case where such leave is granted, proceed to hear the matter accordingly.
Yeah, accordingly, what does that mean? A year's time?
Immediately.
6 months' time?
No, right away.
No, it doesn't mean that.
I would say, Minister, I think what as legislators we want to be clear on is that the matter must be heard within 12 months.
That is correct.
Certainly, that is what Chairman. Certainty as to the fact that it doesn't leave any room for opinion. No. That it must be heard within 12 months. That is the wording. Yes.
And removal of may doesn't cure that.
No.
Doesn't cure it.
Madam Speaker, let's not. We suspend and we return next week and recommit it. No.
Thank you very much, Minister.
That is why I'm cooperating with Lawton.
Members, the question before is that the debate be, not the debate, the procedure in the committee be suspended until the next sitting of the House when the matter can be dealt with thoroughly to in fact indicate what it is that the legislator, we as legislators, would like have written into the law. And I just want for emphasis to say, and I'm saying this for all of us, that when we sit in Parliament and we do these acts and we say, those in favor, the Speaker said, those in favor, we are very eager to say aye and so. Let us read, because I have found, and I'm saying it now because it will come back, there are several things that the legislature could never have intended. That is not what we would want to intend. And we need to make sure that whatever we place in the law is what the legislature intends to have, what we as parliamentarians would like to have there. Members, I do report to the House that progress has been made and there is leave of the House sought to sit again in relation to this matter. I do report progress, but we need to come back to this matter so that the views of the legislators are properly placed in the legislature. Those in favor in the act. Those in favor? Those against? The ayes have it.
Madam Speaker, I rise to just begin debate on the motion that was a notice of which was given last week.
Yes.
And just to very briefly to introduce the Bauxite Production Levy Act, Capital Development Fund Withdrawal Number 1, Order 2021. Madam Speaker, as you and other colleagues here in this honourable House are aware, the Jamaica Bauxite Institute was established by the Government of Jamaica in 1975 as a regulatory planning and development agency to manage the sovereign aspects of the government's participation in the bauxite alumina industry. The JBI was made and is responsible for monitoring and studying the alumina industry and advising the government on matters pertaining to the industry locally and internationally. And, Madam Speaker, is primarily funded from levies on the bauxite industry through the Capital Development Fund. Madam Speaker, the JBI's primary operations are not revenue-generating activities. Accordingly, on establishment, it was understood at that time, and it has continued to be the practice, that the Capital Development Fund would be the main source from which the JBI is funded. Over the years, the JBI has expanded its operations to include the provision of laboratory services on a commercial basis to generate some revenues. However, the revenues generated from the provision of these services are insufficient to entirely finance the Institute's operations. The JBI projects to generate income of $28.56 million from operations during the fiscal year 21-22. However, this is inadequate to meet the budgeted operating costs of $284.97 million. The support from the CDF, from the Capital Development Fund, is therefore critical to allow the Jamaica Bauxite Institute to fund its operations for the 2021-22 financial year. Madam Speaker, the Jamaica Bauxite Institute has been granted budgetary support totaling approximately $1.1 billion from the Capital Development Fund over the 5-year period 2016-17 to 2020-21. This support increased from $211 million in 2016-17 to $244 million in 2020-21. The balance in the Capital Development Fund as at May 31st, 2021 was $1.677 billion, which will be adequate to provide the support required for the JBI. Madam Speaker, this amount was also included in the approved Jamaica Public Bodies estimates of revenue and expenditure for the year ending March 2021. It is proposed, Madam Speaker, that a withdrawal of $255.69 million be made from the Capital Development Fund in line with the Bauxite Production Levy Act and supported by in-budgetary support for the Jamaica Bauxite Institute for fiscal year 2021-22. Mr. Speaker, as I've emphasized since I've started to pilot these orders annually, we're committed and continue to only withdraw from the Capital Development Fund in line with the Bauxite Production Levy Act to facilitate the budgetary support of the JBI, as was contemplated when the Jamaica Bauxite Institute was formed. The Bauxite Production Levy Act Capital Development Fund Withdrawal Number 1 Order Resolution 2021 is hereby submitted, Madam Speaker, to this Honourable House for approval.
Members, the question is that the motion...
Madam Speaker, am I allowed to...
Yes, certainly. Go right ahead.
It's not a controversial matter. It's something which has taken place in the past. The only question or the comment I would make, there has been long-standing complaints from those members who represent communities that are either mined out or bauxite dependent communities about the inadequacies of the provisions in those communities. Not a new issue, so I'm not going to say it is, but just to ensure that those communities for which the fund was originally envisioned, that we ensure that there is, particularly where where there is mined out and there are reclaimed lands for agriculture and other purposes, that we have funds there to promote new industries and for persons to redevelop those lands. But it, again, Madam Speaker, is not something which we are opposed to.
Thank you very much, Madam Speaker. As the opposition spokesman on finance has indicated, this has been an order that has been coming to us periodically to this Parliament. But I want to first of all note that this withdrawal has to do with the funding of the JBI. And Minister, as you can appreciate, we would love to hear of funding for other things, as my colleague has mentioned. And I think it is opportune that we do a relook at the Development Fund and to engage stakeholders, the communities, in serious discussions about the future operations of the fund, the type of works to be done in these communities, and very importantly, the augmentation of the fund, because we know that during the last number of years we have seen the industry going through a difficult period. And I think we need to spend some time to recalibrate, to see how we can, in a reasonable way, ensure that those who are involved in the industry pay what is due. And really, it should be payment as soon as you dig up the soil, even before you do your processing. And so there has to be some reforms where that is concerned. And I think we have to go back to insisting that for all the operators, whether you're jointly owned with government or you operate on your own as private sector, that the bauxite levy be applicable and that we don't vary again from imposing a strict bauxite levy regime, even for Jamaica, where for many years we have not used that system. But for me, it is the most transparent and fair system, and it ought to apply across the board. So my own recommendation is that we apply strictly the provisions regarding bauxite levy, and it should not be varied, but should be applicable to all the players in the industry as we are emerging now out of this crisis. Thank you very much, Madam Speaker.
Thank you, through you, Speaker, Honourable Speaker. Thank you for the contributions from the members on the opposition. With respect to the support for communities in mined-out areas, we seek to achieve that through the central government budgeting process. This Capital Development Fund, we want to withdraw from it for the purposes of funding the JBI, particularly because of the level of the funding now. The funding prior to this withdrawal is about $1.7 billion, which is, it should not be a surprise, is one of the lowest levels that it has ever been at. And if the Bauxite Institute requires $200 million a year, you're talking about 7 years of funding in it. So we don't want to use it for other purposes. But the point about communities that are affected by bauxite mining and recourse through social and other forms of investment in those areas is well taken. And it's through central government, the main organs of the government, that we hope to achieve some kind of fidelity to that principle. With respect to the point made by the member from East Kingston or Port Royal, I got that one right. I agree with you that as a depleting resource that is taken up from the ground in Jamaica, when it is taken up, we should have some tangible benefit that can accrue for future generations. You know the history of the industry as well as I do, and over the past 10 or so years, or 11 years, we have gone through various periods of serious dislocation, which resulted in long periods of either waivers of the levy or an agreement to reduce levy amounts. Unfortunately, that introduced certain patterns that are going to be hard to break, but break we must. And I know the Minister of Mining has been very clear on his position, as far as that is concerned, and is a position that I support. And we will be working to make sure that what you have outlined, is what is achieved. But it won't be easy, and we may have to resort to legal action if necessary. Thank you, Madam Speaker.
The question, therefore, before the House is that the motion be approved. Those in favour? Aye. Those against? The ayes have it.
Madam Speaker, it is not intended to do any further business for today. I therefore ask that the House be adjourned until Tuesday, July 20, 2021 at 2 p.m.
Members, the question is that the House be adjourned until next week, Tuesday, July 22nd. Those in favour? Those against? The ayes have it. This House is now adjourned.
From that bar. If he's not expelled from that bar.
The only bar.
He's not expelled from that bar.
No, I'm going to.
Oh.